Petition allowed.
Obliged, my lord.
Question may I plead for listing of an urgent petition immediately after the vacation. Matter relates to non-receipt of
No,
pensionary
mention has
benefits.
to be made before the senior court.
Lordship, we have already done that, Lordship. The man, Lordship, is yet to get pension even after 4 years of his retirement.
No,
Lordship.
it
There
is
some
fresh matter.
urgency.
Fresh matter.
No. It has to come up for admission. Already affidavit has been exchanged by both the parties.
You go and mention before the senior court.
Senior court.
But this matter pertains to civil bench too.
Maybe.
Senior court.
Ase, no?
Brief, your lordship.
Yes.
Right. This matter may be taken up.
17 and 18.
Taken consent of.
Let it be on 19 also,
19.
19 January.
Okay. As
As
agreed
part-
by learned advocates of both the parties, races shall list the matter on 19 January.
As part heard.
As per that.
Deeply obliged.
Wait, please, your lordships. My lords, in item number 20, you have filed one affidavit yesterday, my lords. That may be called for. Deeply obliged.
Item one.
It pleases your lordship. Lordship, the petitioner has retired from service, lordship. Lordship, grievances regarding old pension scheme and new pension scheme. The authorities are willing to give them give her under new pension scheme, but not under the old pension scheme. Even though it has been squarely covered by WPC number 6403/2021.
Mr. Bora, have you gone through the judgment?
Here, my lord, only stipend status.
Yes, stipend.
Let us verify. Otherwise, my lordship, my disposal of this right to verify the records of the petition of the teacher or not.
So you have filed one representation also.
Yes, lordship.
Is it page number 22?
Yes.
File?
We have filed, representation also filed, lordship, in 2025.
So we are disposing of this petition by directing them to dispose of the petition.
Lordship,
No, dispose of the representation by taking note of the decision of a coordinate bench of this court in WPC number 6403.
6403.
Okay. Okay.
Obliged.
May I please, your lordship. Matter relates to the appointment of the petitioner as a upper primary teacher, lordship. Petitioner applied pursuant to advertisement, lordship, in annexure 7, page 31, post of upper primary teacher, lordship. Thereafter, in the first merit list, his name was appeared. First merit list is page 43, lordship. His name appeared as page 48, lordship, kindly. Lordship, page 48, the petitioner's name was appeared in serial number 15. Page 48, in the right side, lordship, his result was withheld. As in the same list, in the right side remarks mentioned that NIOS certificate was all the applicant, those who have submitted the NIOS aided certificate, lordship, their result was withheld. Subsequently, lordship, in Exar 49, by this notice, lordship, all the NIOS candidates who have submitted their application asking them to submit their UDIs code as well as other relevant document. Accordingly, petitioner also submitted his all the relevant documents. Thereafter, page 50, annexure 12, again asking some document to submit by those who have candidate applied under the NIOS with the NIOS DLS certificate, lordship. Thereafter, lordship, page 51, the final list was published, but petitioner name was dropped without any cause and reason, lordship. Petitioner also approached the respondent authority physically as well as the, before the Lordship grievances department in the respondent authority, Lordship, but he has not get any information why his candidature was rejected, though initially his name was withheld in the provisional list. Thereafter, he submitted all the relevant documents, whatever is required, Lordship, pursuant to the subsequent notice they have issued. This is the case, Lordship.
Yes.
Can you see page 51? Connection. Here, my lord, all the elected candidates were distributed their appointment customer.
But petitioner name was not appeared in the final list.
So he is not qualified. Here, kindly see point number 4. All claim for appointment of any post or picture on the basis of the appearance name in provision by is that will not be entertained.
This is correct, Lordship, maybe entitled, Lordship, but why my name has been
Elected
dropped?
person has already been appointed my lord, on 9/11/2025.
Why my name has been dropped, Lordship? I have also approached them, Lordship. In paragraph 15. This case was filed earlier, Lordship. On last occasion, I could not attend before this honorable court due to some inconvenience, Lordship. Paragraph 15, Lordship, kindly say I have written, Lordship. The respondent authority allowed the NIS certificate once, Lordship. Why my name has been dropped, Lordship? Initially, my name was appeared in the provisional list where they have mentioned that my result was withheld. Subsequently, they have asked for submitting all the relating documents, those who have, whose name was withheld, Lordship, in the provisional list.
Mr. Bora, you obtain instruction.
Instruction, let them obtain.
Already, all the selected candidates were approved.
No, that's right. Even then, and also you obtain instruction
My lord.
whether any post is lying vacant or not.
My lord.
Post is vacant, Lordship, as per
Learned counsel
inspection.
for the petitioner. So P.K. Bora, learned standing counsel for the respondent authority. Respondents in Elementary Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has applied for following reliefs. Number 1, to issue direction to the respondent authorities to issue appointment letter to the petitioner as assistant teacher in upper primary school pursuant to the advertisement dated 26/12/2023. Number 2, to direct the respondent authorities. No, nalage. Nalage. Mr. Hawk, learned counsel for the petitioner, submits that pursuant to an advertisement dated 26/12/2023, the petitioner has applied for the post of assistant teacher in upper primary school. Upper primary school. And thereafter, by a notification dated 17/6/2025, the respondent authorities have asked the applicants to file 18 months DELED from NEOS against the said advertisement with a list of testimonials. And accordingly, the petitioner had appeared in the second phase of physical verification with relevant documents. Thereafter, on 10/9/2025, the respondent authorities have published the first provisional list for the post of regular teacher, upper primary. And the name of the petitioner appeared at serial number 15 in unreserved category under Sri Bhumi district. Thereafter, by another notification dated 25/9/2025, the respondent authorities have directed all the candidates who have submitted their document of DELED from NEOS to submit the UDICE code as well as name of the working school as on 10/8/2017. And the petitioner has submitted the UDAS code and the name of the working school on 10/8/2017. Thereafter, by another notice dated 11/10/2025, the Director Elementary Education has instructed the applicants to submit some information. And accordingly the petitioner has submitted the same. And thereafter on 7/11/2025, the respondent authorities have published the final list of the post of assistant teachers of upper primary school, but the name of the petitioner find no mention in the final result. And being aggrieved, the petitioner approached this court. The submission of Mr. Hope, learned counsel for the petitioner, needs further consideration. And this is Mr. P.K. Bora, learned standing counsel for the respondent elementary education department, is directed to obtain instruction. And also to obtain instruction as to whether any post is lying vacant or not. List the matter. After reopening of the vacation,
Obliged.
May it please your lordship. Whether this matter was fixed for obtaining instruction, my lord. The petitioner, my lord, was appointed as an assistant teacher, my lord. He had 50% disability, my lord. Then he was transferred to a school in a remote area. Then we submitted several representations, my lord, and as per our representations, my lord, the Director of Elementary Education instructed the district authority to adjust him in a convenient school. Yes.
Next year. Let's look at it. Post of the civilian.
Yes, so we can. Please go ahead.
so the matter is pending before the DLC.
My lord. Well,
Or better.
initially petitioner has not submitted his disability. Yes, what I informed that there was no report regarding physical disability of the petitioner during the time of process.
Thereafter, we submitted, my lord, the disability certificates, and that was even forwarded to
Yes,
the,
and now the matter will be placed before the DLC.
my lord,
Let us wait for some time.
my lord, my lord.
First, Mr. S. Das, learned counsel for the petitioner, and Mr. P.K. Bora, learned counsel for the respondent in elementary education department. Pursuant to order dated 10/12/2025, Mr. Bora has obtained instruction and placed the same before this court. And based on the said instruction, Mr. Bora submits that the district elementary education officer Barpeta is preparing to place the matter before the next DLC. And as per approval of the DLC, a further step will be taken in respect of the petitioner regarding the readjustment in a convenient school. In that view of the matter, it is provided that rest shall list the matter after vacation.
Malan,
First week of February.
more time will be granted, Malan.
First week of February, my
First
lord.
week of February. Okay, all right. First week of February. In the meantime, Mr. Bora shall obtain further instruction in respect of the recommendation of the DLC and apprise this court on next date. The letter produced before the court today shall be marked as annexure A and be tagged with the record.
Highly obliged, highly. obliged.
With your lordships, my lords, with my most sincere apologies, this matter may kindly be passed over for the time being, my lords. Deeply obliged.
Only matter. My previous, that matter relates to excess royal of scale, my lord. That in the name of waiving of excess royal of scale, my lord, that last 10 years, my lord, the petitioner is now 70 years, not getting pension. That's why, my lord, lordship may dispose of the earlier direction, my lord, as given in view of the Rosik Moses case, or my lord, maybe it should notice and,
Notice.
my lord, they may dispose of also. Subject to,
Resubmitted to the director of pension.
that's why, my lord, it is pending.
Who is appearing for director of pension?
Director of pension. Those is. This only thing is pending last 10 years, my lord, in the name of otherwise also, my lord, it is not permissible for.
Instead of issuing notice, lordship, perhaps the instruction from the pension department will be expedited law.
When the director of elementary education has forwarded the pension proposal to the directorate of pension,
Yes, my lord, that is annexure B, my lord, annexure B. And in the sixth, B page 16, my lord. Initially, lastly, my lord, the last annexure, my lord. Annexure 20, annexure I page 24, submission of proper justification detailed report in respect of Onima Setia retired teacher, Taku Tribal ME School regarding wave of, my lord, that the excess royal with proper format, my lord, lastly submitted, my lord. And in this way, my lord, from that 16 onwards, my lord, various correspondence. Well, that matter may expedite.
okay. Heard Mr. Goswami, learned counsel for the petitioner, Mr. P.N. Sharma, learned standing counsel for the respondent. Elementary Education Department, and Ms. H. Moore, learned standing counsel for the director of pension. Being respondent number. Being respondent number 3. 3 and 4. Three and four. This petition under Article 226 of the Constitution of India, the petitioner has read for setting aside and crossing the impugned letter number ADP stroke 2017-18 stroke 2017 stroke 09 stroke 0086 dated 8/5/2018 within bracket annexure C and also to direct the respondent authorities to release the regular family pension of the petitioner. At an early date without recovering the excess drawal amount. Mr. Goswami, learned counsel for the petitioner, submits that the petitioner was serving as Hindi teacher at Deoram Taku Tribal ME School under the Block Elementary Education Officer, Bhakuakhana, Lakhimpur. And she has retired on superannuation on 30/4/2016. Thereafter, pension proposal has been submitted by the respondent number 5 to the office of the respondent number 2 on 14/9/2016. And thereafter, by letter dated 8/5/2018, memo number ADP/2017-2018/2017/09/0086. Within bracket annexer C, the finance and account officer of the office of the respondent number 3 has returned the pension proposal on the ground of excess drawal. And asks the petitioner to resubmit the proposal. No, and then the Pension and Public Grievance Department, Assam, by letter dated 25/11/2020, had directed the Director of Pension Assam to submit the proposal waiving the excess drawal struck pension, confirming that the excess drawal is not on account of fraud, misrepresentation, pollution, favoritism, negligence or careless, etc. on the part of the petitioner. Thereafter, the respondent number 2 by letter dated 2/1/2024 resubmitted the pension proposal along with original service book and other relevant papers with excess drawal statement for waiving the excess drawal amount. And the respondent number 5 received from the respondent number 5 and submitted before the respondent number 1 for information and necessary action, but due to delay on the part of the respondent authorities, the petitioner has not been receiving her pension and pensionary benefit for last 9 years. Mr. Goswami also submits that the petitioner is a grade 3 employee and the objection so raised in respect of excess drawal is not permissible. In view of the decision of Honorable Supreme Court in the case of State of Punjab and others versus Rafiq Masis reported in 2015 for SSC double trip. And under such circumstances, Mr. Goswami is contented to allow this petition. At this says Mr. Sharma, learned standing counsel for the respondent in Elementary Education Department, submits that the Director of Elementary Education has already submitted the proposal to the Directorate of Pension.
I'm sorry, Lord. No. Annexure G, page number 21. This communication dated 2nd January 2024 goes to show the director has forwarded to the secretary of the Department of School Education for approval.
Okay, not to the Director,
Director.
Pension.
Therefore, I will obtain instruction. This communication of 2nd January, page number 24, 21.
That was secretary.
Secretary.
Because secretary very lagi na, excess royal
Copy for the respondent in elementary education department submits that by letter dated 2nd of January 2024. The Director of Elementary Education has written a letter to the Secretary to the Government of Assam Department of School Education for waiving excess withdrawal amount.
That was copy to director. Director has given copy, my lord. Below, my lord, director had given copy. Director of pension had given copy. Director of elementary has given copy.
No, waiving power is with the Secretary.
Lordship.
Because
For waiving,
that's why.
Then instruction has to
then
be
yes,
obtained
I
by
will-
you.
I will have to obtain instruction. Because there was some.
Well, that law is settled, my lord. So okay, that can be. Otherwise, my lord,
That can be, otherwise that can be.
can be.
Has to be.
Only the time consuming.
No, let
He
him
will do
obtain
the
instruction
fulfillment.
why it is pending.
Yes, my lord.
And under the given facts and circumstances, it is provided that Mr. Sharma shall obtain instruction from the respondent number 1.
One.
Respondent number 1. Regarding the status of the letter dated 2nd of January 2024 written by the Director, Elementary Education. List the matter on 5th of January.
Lordship.
Good.
Lordship, seventh lordship.
7th.
Seventh. Apply. Item number 6.
May please, your lordship. That petitioner was subject teacher, my lord. While the process of provincialize was going on, my lord, that was her post was, my lord, challenged by another teacher. And ultimately, my lord, in 2000 and obtained stay order. That's why, my lord, her process of provincial was installed. And thereafter, the case was disposed of, my lord, and directed the director to look into the matter and to pass speaking order. Ultimately, speaking order passed, my lord, the petitioner was appointed, my lord, after 1 year. Page 21, my lord, that her appointment order, my lord. Page 21, only. Page 21, my lord. In person. Annexure E, my lord, in pursuance of gov letter so and so dated 25/7/13, whereby 568 number of teaching and non-teaching staff have been created for Nalbari district under the province.
Your service has been provincialized.
My lord, provincialized.
1/1/2013.
Yes, my lord. That was 1/1/2013, my lord, post was allotted, but my service was provincialized with effect from 25, my lord. Subsequently, it was provincialized. After 1 year, my lord, after this order, my lord, 17 December 2004, by speaking order by the director, my lord, 25/11/14. And that both order was challenged by the subsequent writ petition. That was, my lord, disposed of 2005, my lord. Last order, my lord. And thereafter, my lord, I filed a representation because I am deprived 1 year, my lord, because of court stay order. And last 10 years, my lord.
During that period, you were serving in the Said school.
Yes, my lord, sales school. Because of court stay order, I could not get the salary. That's why I filed a representation that is pending before my only submission, the representation may be disposed of, or my lord, let them take instruction. My representation is last, my lord. Page 33.
What to do? Lordship, can refer a matter to the director to dispose of the Okay. Heard Mr. Goswami, learned counsel for the petitioner, and Mr. Dr. learned standing counsel for the respondent in secondary education department. This petition under Article 226 of the Constitution of India, the petitioner has applied for issuing direction to the respondent authorities to release her salary with effect from 1/1/2013 to 25/11/2014, and a scale of pay and increment that may be calculated with effect from 1/1/2013 till date, and to release the same as arrear salary. Mr. Goswami, learned counsel for the petitioner, submits that the petitioner was appointed as subject teacher of logic and philosophy at Dhamdama Higher Secondary School, and she joined on 5/10/2008. And during the process of provincialization, in respect of 568 numbers of teaching and non-teaching staff of Nalbari district, Srimati Reena Devi has filed one writ petition being WPC number 4422 of 2013, who was serving as subject teacher of Sanskrit, challenging the process of provincialization of the petitioner. And in the said writ petition, interim stay was granted on 8/8/2013 in respect of provincialization of benefit of the petitioner. The said writ petition was finally disposed of by this court by order dated 21/5/2014, directing the Director of Secondary Education to decide the matter by taking note of the relevant facts and circumstances, and in accordance with law, and providing opportunity of hearing to both the parties, and to pass a speaking order. And thereafter, the Director of Secondary Education passed the speaking order dated 25/11/2014, whereby service of the petitioner has been provincialized in the subject of logic and philosophy with effect from 25/4/2014. And the post of the petitioner was allotted to Dhamdama Higher Secondary School with effect from 1/1/2013. Thereafter, by another order dated 17/11/2014, her salaries were released with effect from 25/11/2014. Thereafter, said Reena Devi again challenged the speaking order dated 25/11/2014 and the order dated 17/12/2014 by filing a writ petition being WPC number 2604 of 2015. But no stay order was granted, and as such, the petitioner was allowed to continue her service without any break. And the said writ petition was disposed of by order dated 9/3/2025 as not pressed by the petitioner. Mr. Goswami also
The
submitted
annexer F, my lord, that page 22, that was argued, but at lastly, after argument had not as not to be pressed, my lord, that was withdrawn. Annexer F, my lord, that the
Okay.
last portion is, my lord, page
Mr. Goswami,
28,
others
it is
understand.
clear.
Although 560 numbers of teaching staff and non-teaching staffs have been created for Nalbari district, pursuant to the government letter number ASE 86/2013/PT-Roman 2/301 dated 25/7/2013, the petitioner's post was allotted by the order dated 17/12/2014 with effect from 1/1/2013. But the salary due to her was not released by the respondent authorities. And since the WPC number 2605 of 2015 has already been disposed of on 19/3/2025, now there is no impediment in granting the aforesaid relief to the petitioner. And accordingly, the petitioner has filed one representation to the respondent number 2 on 30/7/2025, praying for releasing her salaries with effect from 1/1/2030, but the same is yet to be disposed of by the respondent authorities. And as such, Mr. Goswami submits that this petition may be disposed of by directing the respondent number 2, the Director of Secondary Education, to dispose of the representation dated 38/7/2025 in a time-bound manner. Mr. Dotto, Learned Standing Counsel for the respondent in Secondary Education Department, submits that he has no objection in the event of disposing of this writ petition at this motion is says itself by directing the respondent number 2 to dispose of the writ petition, the representation dated 38/7/2025 filed by the petitioner. Accordingly, as agreed upon, and also taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the respondent number 2 to dispose of the representation dated 30/7/2025 filed by the petitioner within a period of 4 weeks from the date of receipt of certified copy of this order by a speaking order. The petitioner shall obtain a certified copy of this order and place the same before the respondent authorities, along with the representation dated 38/7/2025 and a copy of the writ petition within a period of 1 week from today.
Mal. Obliged.
For 8 weeks instead of for 8 weeks.
6 weeks in between. Duna more.
Okay, 8 weeks.
Malad, because thereafter election come and all matters will be pending. Oh, oh. 8 weeks.
Lordship, let this matter be passed over for time being. My senior is on legs.
Instruction. I have received a communication from department that 2 weeks time required and similar matters are already fixed on 9 January. The series of matters can be fixed. The matters on 9 January also. Till then-
9th of January.
Yeah. Other matters are 732 Similar matter can still
Lordship.
accepted in the ground of itself.
Lordship, kindly wait for my senior, Lordship. Let
Who
him,
is your senior?
PN Goswami, sir.
Let him come.
Uh,
Okay, you may go.
Yes, Lordship, 9 January.
I will say, let Mr. Goswami come, or if convenient, you can come.
Yes,
Item 7, 8 is also same, Lordship. 8, item number 8. This one is 7 and item 8 is also same.
You ask your senior to come.
Oh, okay, yes, Lordship. Obliged.
public.
Item 9.
My please lord. Herein the petitioner, the petitioner had participated in the recruitment process for the post of Constable ZD in the Central Armed Police Force, your lordship. I think madam. Herein their candidature has been rejected only having found cut mark in their hands, your lordship.
Hmm.
Although the
Have you
medical,
served the copy?
yes, we have served the. Why doesn't put there?
She has some other matters. Let her come after some time.
Obliged.
May please your lordship. An advertisement was issued by the respondent for appointment of
gazette teacher. One of the condition of the candidate must pass the HSLC examination with Assamese language as one of the subject. One of the condition in the advertisement. Mill. Petitioner applied, call letter issued, he appeared in the written examination, and this is a process, my lord, examination and appointment on the basis of result. The petitioner secured 99 marks, but his name was not included in the select list. Then he applied for the under RTI, to know the reason of non-inclusion of his name in the select list. The RTI replied that I have not fulfilled that condition, my lord. That my I have not Assamese language in the HSLC examination. That clause, your lordship has a look at page 17, my lord. Has your lordship got it? Page
70,
7.
page 70.
17.
Yes.
Down below, my lord.
Hmm.
In case, has your lordship got it? In case of Assamese medium school, has your lordship got it? Page 17, 17. In addition to the academic, down below, my lord.
Got it.
Roman 1, my lord. In case of Assamese medium school, the candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects. Now, your lordship, kindly turn to page 14. Admit card in HSLC examination.
No. You have enclosed your mark sheet also,
Yes, my lord.
page number 15.
Yes, my lord. The subject is
uh,
Assamese and English in my alternative, sir.
No, as per advertisement, Assamese should be a subject in which examination?
In HSLC examination.
SSLC. Okay.
These are the two admit card and the mark sheet in the HSLC examination, my lord.
So this mark sheet is sufficient to show that you have Assamese in SSLC examination.
Examination, yeah.
Okay.
And therefore, I am proceeding this order.
Where is the RTI reply?
At page below, RTI reply at page 61, your lord. You find it? Have a look. Has your lordship got it? One, due to non-fulfillment of criteria of in para C 1, 2, 3, 4, 5, 6, as per advertisement published by so. The other clause are not relevant and not applicable to me, my lord. 2, 3, Roman 2, 3, 4, 5 in the advertisement. Those are not connected with me. Because in case of Bengali,
in the reply, they have mentioned that para C, Roman 1, 2, 3, 4, and 6.
my lord, only one is applicable for me in my case.
How?
My lord, your lordship kindly turn to Roman 2, my lord. Have a look on it, Roman 2. In advertisement, page 17. In case of Bengali medium school, I am not in Bengali medium school, my lord. 3, in case of Hindi medium school, it is not a Hindi medium school, my lord. In case of Bodo medium, it is not a Bodo medium school. I have applied for Assamese medium school. In case of English medium school, the other clause are not at all applicable for me.
But they have mentioned it in the
No, I
reply.
have mentioned it. I don't know, my lord, because that is not relevant in my case. because I have applied for Assamese medium school.
Yes, Mr. Musari.
But final is published on 17/6/2025. And moreover, Lordship, appointments were made almost months ago, Lordship. Months ago, almost 5 months. Now, not really in filing this.
Look, I got the RTI reply in October, my lord.
No.
RTI reply October.
Petitioner Lordship.
Delay
well,
of 2-3
why-
months.
Why did not you approach this court as soon as you have received the RTI reply?
October, my lord, October, November, December.
No, you see, in the meantime, they have already issued appointment letter.
No, my lord, so far appointment, let them, they already issued, I admit it. It is not that case, why, this is the illegality, violation of Article 14. I was not
No,
treated
that's all right.
equally.
Now, if all the posts
That
are
is up to
filled
the
up,
court. Yes, that is up to the court. If I say, if your lordship holy, then they have to accommodate me anyway.
no, if there is no post, then
Post is, then the question would have been different, but they have not said the post is not there.
okay, let him obtain instruction.
Let them file affidavit, my lord, that will be clear. And this is notice?
Notice.
Notice.
Heard Mr. Kakute, learned counsel for the petitioner, and Mr. Musari, learned standing counsel for BTC. Being respondent number 1 and 2. The petitioner herein has tried for issuing direction to the respondent authorities. No, for declaring the action of the respondent number 2. Respondent number 2. For non-inclusion of the name of the petitioner in the select list as illegal and arbitrary and violative of Article 14, 16, 19, and 21. And also to issue direction to the respondent authorities to consider the case of the petitioner for being appointed as graduate teacher arts. Mr. Kakute, learned counsel for the petitioner, submits that pursuant to an advertisement dated 13 February 2024, the petitioner being qualified had applied for the graduate teacher arts. And he also appeared in the examination, but his name find no mention in the select list. Thereafter, the petitioner has filed one RTI application. And on receipt of the reply, he came to know that he was not selected due to non-fulfillment of criteria number C, within bracket Roman 1 of the advertisement. Mr. Kakute submits that the said criteria, under the said criteria, the candidate must have passed SSLC examination with Assamese language as one of the subjects. And referring to the admit card, which is annexed with the petition as Annexer A, and the mark sheet of the SSLC examination being annexed with the petition as Annexer B, submits that the petitioner has fulfilled the aforesaid criteria, but despite fulfilling the aforesaid criteria, the candidature of the petitioner has been rejected by the respondent authorities. And as such, the action of the respondent authorities are illegal and arbitrary and liable to be interfered with. Mr. Musahari, learned standing counsel for the respondent number 1 and 2, however, submits that at this instance, notice may be issued to the respondents so that he may file the affidavit in opposition. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Musari entered appearance for the respondent number 1 and 2 and received notice. But extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks. In the meantime, Mr. Musari shall file the affidavit in opposition. After 4 weeks.
Item 25.
May I please, your lordship? Petitioner before lordship. Petition number one is a Bajali Teachers Training College. Teachers, we give imparting teachers training be addition to teachers, my lord. What this is affiliation to Guwahati University, and regulation is under NCT. We go for different regulations there. One public notice was issued for ITP course, my lord, that is Integrated Teachers Education Program. Accordingly, we have filed application paying 1,50,000, my lord. And after receiving that application, so far notice was used for some deficiencies. We have replied to that. Thereafter, we are waiting that this will be, our case will be considered in terms of that is 2014 regulation. It is issued by, published by NCT. But when we come to know that our application is being rejected, that we have not received 10 marks. But it is at same time we have seen another college who has established later than us, and there here one point is very essential, gradation of NAC. And we have received, we have got B2, as you know, B plus, where you are B plus, but that Gusaigaon College is getting B, meaning their way, B plus we are getting more marks than Gusaigaon. We are not against the, we are not having any grievances against the Gusaigaon College. It is not that we want to know to region. That is how we have filed an application, a special application to consider as a special case, my lord. But no reply has come so far. Now, today is my lord, it is lordship may issue notice to the respondents, and in the meantime, my prayer will be first as an interim measure that the pendency may not be barred to consider my case on the basis of my application which was filed as a special case. Because here again I am citing Miller that we do not have any grievances against it, but we want to know because equalitative law and equality, the Nagara case is there because deficiency, this cannot be discrimination between two colleges. That is why we have made them as a proper respondent. And that is why we do not have grievances, you have said, but if they are contesting, they will be treated as the main, as per law, they said they will be treated as the main defendant. Here only today, because until unless your lordship replies come or everything, then it will be, we cannot go ahead because that's a notice may be issued. My humble prayer and submission, my lord, that is my submission of a prayer, that maybe notice may be issued, let them file affidavit. In the meantime, they may consider. By that, consider my case if they found eligible, or if he's rejected my special application which is filed to consider that, let me reject my decision with giving reasonable grounds so that I should know about why it is been discrimination was there. Whether discrimination was there or not, they will decide. Because today itself I am not, but by mere observing this all decision of the NCT, then we are coming to know because as per our calculation, we are supposed to get 8 points. and they're supposed to get 7 points. They might have, there's a provision, my lord. Another thing, the regulation 2014, there is a provision for relaxation. They might have, this college might have given relaxation, or that is also is known to us. If relaxation is given, we are also applicable to as per clause, regulation 14.12, my lord, which I have annexed before, along with this application, this regulation. They may consider my case a special case also. That's why, my lord, today my humble prayer, submission and prayer before lordship, notice may go, and because their admission will be likely to do for though it is July, August, they conduct an entrance test, January, February itself, let them file by affidavit. And in the meantime, they may consider, or they may reject my decision, but I am entitled to at least to know my disposal of my representation. That representation, let them reject my reasons. Then also I should know this. It's my humble prayer today.
Yes, Mr. Alam.
This repetition is not mandatory in view of section 19 of the ST Act, my lord. That is the appeal provision, my lord. Against the rejection order is the 10/12/2024. They should file the appeal before the appellate authority at the LCT.
Under
With their
section,
grievances, my lord.
under section,
Under section 19, I have a copy.
But we have filed application. But before that, we have filed one application also. That may be treated as an appeal.
No, my lord, that's the appeal.
No.
Here is there. Section 18, my lord.
তেতিয়াহ'লে appeal procedure লৈ লওঁ। চাওঁ এইটো কিমান হৈছিলে LCT? আমি appeal কৰি লৈ লওঁ। appeal কৰিব পাৰিব।
আপোনাৰ ফৰ্ম চল্ভ কৰিব।
তেতিয়াহ'লে observation, this appeal, we prefer.
yes, Mr. Borua,
If so, my lord, I have seen just now, this it is also, if appeal provision is there, lordship definitely not entertained. Now, my humble prayer before lordship that this may be disposed of, not this one with a direction, we may be, as a provision, we will may be allowed to go to. Though it is not required, but observation is, court is, as I am before lordship, this line will, yes, we'll file appeal before this observation is little, it will help us for this. That if limitation also is there, that will be covered up.
heard Mr. Borua, learned counsel for the petitioner,
By submission of the
and Mr. Alam, learned standing counsel for the NCP. The petitioner herein is Bozali Teachers Training College situated at Patasarkose. They are aggrieved for rejection of their application. By the Eastern Regional Committee, which include ERC, NCT, in its meeting held on 3/48 on 6/7 August 2024. Whereby the petition filed by the petitioner was rejected on the ground that the institution does not qualify the shortlisting criteria of minimum 10 points for processing of the application on the basis of extant norms and standard prescribed by NCT. Mr. Borua, learned counsel for the petitioner, submits that without giving any prior opportunity to clarify the drawback, if any, the petition was rejected by the NCTE, but they have granted the permission to to Bokhaigaon B.Ed College. Bokhaigaon B.Ed College. No, but they have issued letter of intent, LOI, to Bokhaigaon B.Ed College. Who has secured, who has secured 7 points only. But the petitioner herein has secured 8 points, but despite securing 8 points, they have not considered the application filed by the petitioner. And as such, Mr. Borua submits that a this notice may be issued to the respondents. And also, it may be observed that pendency of this petition should not be a bar in disposing of the application filed by the petitioner. To the respondent number 4 and 5 on 14/7/2025 and 15/9/2025. However, Mr. Along, learned counsel for the respondent NCTE, has vehemently opposed the petition. Mr. Along submits that in view of section 18 of the NCTE Act 1993, there is provision for appeal against any order made under section 14 and 15 or section 17 of the Act, and without exhausting the aforementioned provision, the petitioner is not entitled to move the present writ petition directly before this court. At this stage, Mr. Borua submits that this writ petition may be disposed of by directing the petitioner to approach the respondent authorities by filing an appeal. As provided under section 18 of the said Act. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner to approach the appropriate authority under section 18 of the NCTE Act. And in the event of filing such an appeal, the respondent authorities shall consider and dispose of the same in accordance with law. Terms of this writ petition stands
Hello.
disposed of.
Disposed of, Miller. Well, may I pray this on one? We have secured 8 points means supposed to, what is there? It is our calculation. Anyhow, lot this of the order.
Clearly mandate.
Yes. Oblige, Miller.
Section 26.
May I please, Your Lord? Lord, the present case, my lord, pertains to the appointment on compassionate ground, my lord. More. So in fact, my lord, the mother of the present petitioner, my lord, earlier applied, my lord. The father of the petitioner died in the year 2006, and in the year 2006, my lord, the mother applied. But that, my lord, the respondent authorities took, my lord, as many as 13 years, my lord, to decide the application of the petitioner's mother, my lord. And White Annexure 9, my lord.
No, you see, after rejection of the petition filed by the mother,
My lord.
is there any provision for filing a fresh application by the son?
Because, my lord, my contention is that, my lord, the mother's prayer was not rejected on merit, my lord. Because there was no, my lord, vacancy in between, my lord, 2 years, therefore, her application got to be rejected. Your lordship will find at page number 39, my lord. Page number, my lord, relevant portion, your lordship will find at page number 43. Yes, 43, my lord, serial number 18. That married, my lord. Office of the District Elementary Education Officer, Kamrup Metropolitan District, Guwahati, Grade 3 Assistant Teacher's Post. My lord, here, my lord, the on the basis of the available vacancy, the proposal of so-and-so was allowed, my lord. And then proposal of also one Sri Shyam Saikia and Rahul Kalita, these were allowed. But next paragraph, my lord, the proposals in respect of the following candidates have spent their force as they have been lying pending due to the dearth of vacancy for more than 2 years as per Government Office Memorandum number so and so dated so and so, which state that the applications which remains pending due to the want of vacancy for a period of 2 years from the date of making such application, all such applications will require no further consideration and must be understood to have spent their force. Then in this list, my lord, serial number 11 is my name, my lord. So on merit, my lord, my prayer was not dismissed or rejected, my lord.
No, this spent force means already several years elapsed.
But at the same time, my lord, that in the meantime, the petitioner acquired the eligibility, my lord, and therefore she applied in the year 2022. Even if, my lord, that my application was received, my lord, and that they alleged that, my lord, they placed my case, my lord, in the DLC in the year 2022. But I have been communicated the decision only on, my lord, 21/3/2025, my lord. So that is the contravention of the office memorandum, my lord, dated, my lord, 1/6/2015, my lord, because that paragraph 24 specifically says that if a speaking order is passed, that has to be communicated and reasons, my lord, should be assigned. And the ground of reasons, my lord, as stated in the impugn order, your lordship will find at page number, my lord, page number 53, my lord. If they have placed my case, my lord, in the year 2022 and rejected it on this ground, it was incumbent on their part to communicate the, my lord, decision to me
When you have filed the application?
in the year 2022, my lord.
22.
22, my lord. In the year 2022, in
Then,
fact, I have not got the copy of the application, but annexure
When the
10,
father of the petitioner died?
2006, my lord,
6.
2006. Mother applied in the year 2006 only. The petition, the matter kept pending, my lord. And it was in the year 2019, your lordship will find the, my lord, DLC minors, that in the year 2019 only, the case of the petitioner's mother kept rejected by DLC dated 30th of September
Let
2019.
notice go at this, you file your affidavit.
Cannot transfer lordship. Already lordship, my mother case has been that lordship. And
No, my lord.
as per when the 2015 principle stand lordship. Her case has been rejected.
Okay, you file your affidavit.
Mine.
Let notice go. Heard, Mr.
A. Ali, my lord.
Learned counsel for the petition. And Ms. Bowman for the respondent authorities. The petitioner herein has challenged the communication dated 21/3/2025, which is bracket annexure 50, whereby the pair of the petitioner for being appointed on compassionate ground has been rejected by the respondent number 4. Respondent number 4. Way back in the year in 2022. Mr. Ahmed, learned counsel for the petitioner, submits that the father of the petitioner
My lord, death certificate is page number 27, my lord.
was working as assistant teacher at Sangsari Adorso SS School. And he died in harness on 7/11/2006. After his demise, the mother of the petitioner has applied for being appointed on compassionate ground. In the year?
My lord, 2006, my lord.
No. In which year the mother of the petitioner applied for?
My lord, 2006, my lord.
2006.
Yes, my lord. Your lordship will find it at page number 30, my lord.
Page number?
30. This is the headmaster who has forwarded the letter, my lord. This speaks of, my lord, that the mother applied.
On 27/11/2006. But the same was rejected on, when it was rejected?
My lord, 30th of September 2019.
Page number?
2019, my lord. Page number, my lord, this is 43, my lord. 43. And DLC, my lord, your lordship will find it page number
And the
37.
same
That
was
is the my lord.
rejected
37, my lord.
by the district level committee on thirtieth nine, 2019.
my lord.
Annexer 37? No, sorry, Annexer 9.
Annexure 9, my lord.
At the relevant point of time, the present petitioner was minor,
My lord.
and she has attained majority in the year
My lord, in the year 2020, she completed her master's, my lord.
in the year
21, my lord.
2021.
She completed master's,
The petitioner has completed
master degree,
master degree in computer science,
my lord.
and thereafter she has applied for being appointed on compassionate grounds. But the same was rejected by the respondent authorities in the year 2022, but it was communicated only on 21/3/2025.
My lord.
Then being aggrieved, the petitioner approached this court by filing the present petition. And what is the ground?
My lord, the ground is sense of candidature, my lord. On account of sense of candidature,
Page
my
number?
prayer 53, my lord.
And the ground for rejection was there is no provision of change of candidature in different time. Different time. The submission of Mr. Ahmed needs further consideration, and this is notice be issued to the respondents returnable in 4 weeks. That be taken. No, however, no formal notice is required to be issued since Ms. Bowman entered appearance and received notice. However, extra requisite copy of the petition may furnished to her during the course of the day. Leaves the matter after 4 weeks. In the meantime, Ms. Bowman shall file affidavit in opposition.
I am obliged.
27.
My lord. Petitioners are the LPME teachers of different ME school, my lord, MB school. They are appointed during the year 2004, my lord. Their service has not been regularized, my lord.
Yes, Mr. Sharma. Notice. The petitioners herein are praying for issuing direction to the respondent authorities for regularization of their service. In the post against which they were appointed, or to adjust the petitioners against resultant vacancies of the district or state. The learned counsel for the petitioner submits that the petitioners are eligible for being appointed as teachers in different LP and B schools. and they were appointed in the year 2004. And their appointments were communicated to the authority concerned with a prayer for regularization. But the same failed to evoke any response till date. And being aggrieved, the petitioners approached this court by filing the present petition. Mr. P. N. Sharma, learned standing counsel for the respondent authorities, however, submits that at this assess notice may be issued. At this assess notice may be issued. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by.
And for respondent number 2, 3, 5, and 6, Lordship.
Mr. Solia is there.
One friend. 1.
Ms. Goa for respondent number 1, Mr. P. N. Sharma for respondent number 2, 2, 3, and 4.
Finance. Respondent number 4.
2 and you are for 2 and 3,
I am for 2, 3, 5, and 6, Lordship.
5 and 6. Mr. Solia for respondent number 4. Since all the respondents are represented by their engaged counsel. But extra requisite copy of the petition be furnished to them during the course of the day, less the matter after 4 weeks.
Item 28.
20. Conventional appointment, Lordship. Petitioner not challenge OM. This case is pending before DLC, Lordship.
Well, Lordship, already he has applied, Lordship. As per SOP of the law.
Similar, Lordship, on 12th, Lordship, this honorable dispose of.
If he has already applied for, then let it be placed before the SLC.
No, no, DLC.
SLC will,
Verification considered there, Lordship, applicant.
who will consider?
Personal department, as per SOP of the personal department, after verification, if they are eligible, then it is before the LC or DLC. Lordship.
Already applied, personal department.
Lordship, I cannot, no, not required.
No, OM challenge, Lordship, dispose of the similar, Lordship, one, Lordship, on 12th, Lordship, dispose of.
No, you see the order then. But I say copy of this order to her. You let me know after some time. You go through the order. Next.
29.
Taking.
Lordship, a password matter for time being, Lordship, learned senior counsel K. N. Suri will appear, Lordship. He is only.
Item 30. Item 30.
May I please the Lordship? Herein the petitioner, he had participated in the recruitment, Your Lordship, for the post of Constable GD in terms of the recruitment notice dated 24/11/2023. And all the process of selection he has completed. And but unfortunately, the name of the petitioner has been included in the list of withheld candidates, Your Lordship. But the selection process. Good. Page 48, Your Lordship. The selection process, Your Lordship, basically consists of computer-based examination, thereafter PAT and medical, and thereafter doctor.
Why your name is placed in the withheld list?
On my personal inquiry, Your Lordship, the petitioner, he was informed that his biometric was not completed, Your Lordship.
Biometric was not?
Completed. Although it was taken, but due to technical error or technical failure, it, they could not complete it, Your Lordship.
So is there any provision for,
Lordship,
is there any provision
Yes.
for retaking it?
I have to take instruction, Lordship, why, whether biometric has been taken or not. They have stated that there was not taken due to technical problem. But let me have my instruction, Lordship, why it was like that.
Okay. Heard Mr. A.M. Khan, learned counsel for the petitioner, Mr. Roy for the respondents in,
Others.
all the respondents. Mr. Khan, learned counsel for the petitioner submits that the petitioner has participated in the selection process for the post of constable stroke ZD in CAPFS. Pursuant to the recruitment notice dated 24/11/2023.
Selection process.
And
under rank of
the petitioner has successfully completed all such necessary formalities of selection and appointment to the post of constable ZD in CAPF in terms of the recruitment notice dated 24/11/2023. But the name of the petitioner has been placed in the withheld list of candidates in the final result published on 14/12/2024. Mr. Khan submits that on being inquired, the petitioner came to know that his candidature was rejected, his result was withheld on account of, in which paragraph you have mentioned it?
There are 13, Your Lordship. There are 13. Page 9.
On account of non-completing biometric of the petitioner.
Yes.
Of the petitioner, and the same has been informed to him by respondent number 5. Respondent number 5. At this instance, Mr. Roy Learned, standing counsel for all the respondents, submits that he may be granted some time to obtain instruction as to on what ground the name of the petitioner is placed in the withheld list. Where is allowed, recess shall list the matter on
21.
January.
Lordship,
It will be too long.
Lordship,
Short date.
Lordship, after that, on 9th then, Lordship.
9.
Nine.
9.
Lord.
So as to enable Mr. Roy to obtain instruction.
Lordship, I have item number 9. I have to obtain the instruction, because left over I was not present, Lordship. Item number 9 may be. Same petition, Lordship.
And what is the ground here?
Here,
Herein-
Lordship, review medical board has rejected him.
Review medical board.
On cart mark, Your Lordship, was found.
I have to
Heard Mr. A.M. Khan, learned counsel for the petitioner, and Mr. Roy for the respondent. Mr. Khan, learned counsel for the petitioner, submits that pursuant to the recruitment notice dated 5/9/2024, the petitioner has participated in the recruitment drive for the post of constable from ZD in CAPFs. When he had qualified in the written computer-based examination and appeared for the physical standard test and physical efficiency test and succeeded the same. Thereafter, the petitioner had undergone detailed medical examination. But ultimately, his candidature was rejected on the ground of hesitation cut mark over his left forearm. Mr. Khan submits that subsequently the petitioner had appeared before the RME Board 2 for his review medical examination. And the review RME board found RME board has not found any. RME board 2 is constituted by whom?
RME was constituted by the department.
Department. Your department.
Yes.
And RME board held that you were unfit for
Yes. Page number
appointment.
53.
Yes?
52 and 53, your lordship. Two declaration, no?
Subsequently, the petitioner has appeared before the RME board 2 for review medical examination, and the RME board had found the petitioner unfit on account of multiple hesitation cut on 25/11/2025, and hesitation cut indicates past self-harm behavior.
Lordship.
But Mr. Khan submits that the Department of Psychiatry of Guwahati Medical College Hospital has not found any psychopathology deformity with the petitioner. And being aggrieved, the petitioner approached this court by filing the present petition. Mr. Roy, learned counsel for the respondents, however, submits that he may be granted some time to obtain instruction in this regard. Fair allowed, rest is the matter on same day, 9.
On 9.
So it's enable him to obtain instruction.
Lordship, herein interim prayer is there, your lordship.
Lordship, let
There
me-
is,
on 9th, Lordship, let it.
On that day, entire
Then
period of the
the
petitioner
interim will be considered on
9th.
yes. All right. And
Timing 28.
Page number 47. Abdul
No, madam, you say,
Yeah.
you verify the matter, and if it is not suitable for being placed before the SLC, you reject it.
We cannot send the OM, but if I 24.
It is
No,
OM
yeah,
silence.
as per this notice, they cannot.
Yeah,
Already
already over, that's that net, it is next and.
If it is, if it is not suitable for being placed before the SLC, you reject it.
Plus DLC. Our case is DLC.
DLC.
Plus. Problem.
Timing 29.
Wait, please, Your my lord, I'm challenging an order of suspension, my lord. Normally, I would not have made a prayer for interim relief, but I'll explain the circumstances. Please come to page 69, my lord. In pursuant to the letter dated 13/12/25, received from the Director of Secondary Education, Assam, Mohammad Elis Ali LDA Senga Higher Secondary School is hereby placed under suspension
under Rule 6(1) of the Assam Services Discipline Appeal Rule and pending trial of a departmental proceeding. Mohammad Ilyas Ali, LDA of Senga Higher Secondary School, Borpeta, is placed under suspension with immediate effect in connection with anomalies in conducting HSLC examination. Fake candidates to appear in HSLC examination at Senga Higher Secondary School. Malad, the allegation is I am responsible for, Milord, some candidates with fake, Milord, papers appearing in the exam. Who am I, Milord? I am a clerk. Who am I, Milord? The principal is the in charge. Milord, this Senga Higher Secondary School, under it, Milord, there are 8 feeder schools. Now all the schools, students of all these schools appear here. Milord, there is a catch to the entire scenario, Milord. What had happened? Milord, there is a girls' high school, Senga Girls' High School. Milord, it has got its DIAS code, but it doesn't have any student enrollment. Now, there is another private institution by name Brilliant Academy. Diligent Academy. Now, the director of that school, of that private institution, Milord, what he does a deal with the Senga Girls' High School, and he, Milord, permits his students by appearing in the matriculation examination from Senga Girls' High School. Now, the modus operandi which is adopted by these other gentlemen, this MD of that Brilliant Academy, what he does, Milord, Lordship knows the registration has to be done in class 9. Supposing, Milord, I am supposed to appear in HSLC next year, I'll have to register when I'm in class 9. What he does, Milord, he registers some false name he registers, Milord. Supposing, Milord, he takes about 20 excess. And what he does subsequently, Milord, in connivance with the SEBA people, Milord, he manages to put in the name of those who will appear from his school in that Senga thing. This is how it operates. Milord, the principal is in charge. I am a clerk. Who am I to allow, Milord? If somebody comes up with a admit card, then I am bound to, I have got nothing to do. As a clerk, my duty is confined to the office. Whether I am not the person to check the admit card, it is the principal and the other invigilators or the teachers in charge will do it. Now, Milord, I'll give there are 2 letters which will clarify what I am saying, Milord. One is the letter of the principal, and other is the petitioner's reply. Please come to page 58, Milord. Wait. Before that, Lordship will kindly come to page 47. Now, this is the undertaking given by that Abdul Rauf Ahmed of that, Milord, Diligent Academy. Now, kindly see, the roll numbers are indicated. I do hereby undertake that I shall get documents of the students whose roll numbers have been cited above, duly corrected during examination period. I further assure that I shall extend my full cooperation in every aspect to ensure smooth conduct of the examination at the examination center, Senga Higher Secondary School. I also undertake that in future I shall not register any new student of Diligent Academy in the name of Senga Girls High School. Further, I accept the sole responsibility for any difficulty that may arise in future. So this is an undertaking which was given by Milord Abdul Rauf Ahmed, director of that institute. And it was in the course of a meeting, Milord. At page 44, this is the minutes of the meeting, and it was given. Now, Milord will kindly come to page 58, a communication by the principal to the inspector of school. At page 59.
Yes.
Milord will kindly come to the second sentence. There are 8 numbers of feeder school under Senga Higher Secondary School, namely so and so. All students of the aforesaid school used to appear in HSLC examination, sitting in our higher secondary school as the examination center. Each school has their own school DICE code. Principal of each school apply for registration of their own candidates.
Senga Girls High School is situated just in front of Senga Higher Secondary School. For the last 3-4 years, there are neither any student nor any teacher of their own in Senga Girls High School. That the dexterous headmaster of Senga High School, namely Samsul Haq, notwithstanding having not any student or teacher of their own, illegally using the dice code till today without surrendering the same, it is reportedly alleged that Samsul Haq without justification facilitated 30-40 number of students to sit in pre-board examination at Senga High School every year without providing any invigilator. In this regard, we brought it to the notice of the superior authority several times. Besides this, we furnished a written complaint in this regard before the Honorable Secretary, so-and-so. It is brought into light another fact that one Abdul Rauf Ahmed is running to academy under the name of Diligent Academy Private School without having any dice code of his own, situated at Padmapara and Senga, and maintaining a secret nexus with Samsul Haq. The said Abdul Rauf Ahmed is also managing some students and facilitate those students to appear in HSLC examination in this year using dice code of Senga Girls School. So this is the version of the principal which supports my case. Then my lord will kindly come to finally at page number 64. That is the reply of the petitioner, my lord, which he gave to the additional deputy commissioner. I have the honor to state, page 64, my lord.
Yes.
I have the honor to state that I am serving as a lower divisional assistant at Senga Higher Secondary School. On a certain date, the exact date of which I am presently unable to recall, Sri Abdul Rauf Ahmed, Managing Director of Diligent, requested our principal to affix seal of the center in charge along with counter signature of 9 admit card for the year 25, claiming that requisite correction has already been carried out through SEBA. Subsequently, the principal asked me to examine the said admit card. Accordingly, I scrutinized them and compared them with the photos of the attendance sheet. I was surprised to find that several major errors have been corrected. I immediately brought this matter to the notice of our principal. Thereafter, principal entrusted me with the responsibility of getting the admit card verified from SEBA on the following day. Accordingly, I visited SEBA office and met an official whose designation I am not certain of, possibly Deputy Controller or Assistant Controller. The name Subham Kasari was displayed on his nameplate. I handed over 9 admit cards to him and requested him to verify whether they were genuine or not. Upon examining the admit card, he declared them to be incorrect, wrote the word cancel on them and discarded them into the dustbin. I then requested him to return the cancel admit card to me so that I could take the photographs of them. When he gave those to me, I took photograph of the same. Later, I showed them to our principal. That is all the knowledge I have regarding matter. My lord, without the connivance of SEBA officials, this is not possible. Because registration is done by SEBA. My lord, who am I, my lord? And I have been placed under suspension. Scapegoat. My lord, what role do I have, my lord? And my lord, as a LDC in the school, my role is to confine to my office duties, my lord. And it was basically when I went to the SEBA's office, when I pointed out, my lord, as instructed by the principal, then the actual thing came to light. Earlier, the SEBA officials permitted. That's why they came to take admission, my lord. But subsequently, when I confronted them, then they said this is wrong. If a police case is registered, my lord, everything will be out. Now, unless the SEBA officials are hand in gloves, my lord, this is not possible. And my lord, the principal has clearly stated my role. And only a show cause notice explanation has been issued to the principal and I have been placed under suspension. Well, it is absolutely a disproportionate action, my lord. Where is the question of I being placed under suspension? Therefore, my humble submission is, my lord, Lordship will consider passing some appropriate interim order, my lord. Otherwise, it sounds very innocuous. Pending trial of a departmental proceeding, you are placed under suspension. Because suspension as such is not a punishment. What is wrong in it? Prima facie impression, my lord. But end of the matter, this is what is happening. Now, if ex-school student comes with a forged document to appear in the examination, my lord, what role do I have, my lord? Because I am a clerk, therefore, it must be shown that some action has been taken. Therefore, might as well suspend the, my lord, LDC. And it was basically I who, my lord, pointed out. In fact, principal has also noted that at page 60, my lord. If your lordship would kindly come to page 60, my lord. Third sentence, but feeling some smell of rat, I did not put up my signature therein. I accordingly deputed one, namely Ellis Ali, that is the LDC, to the office of the SEBA to verify the authenticity of the same. On being arrived at the office of the SEBA, when Ellis Ali show 9 admit card to other officers of SEBA, then the authority concerned were cancelled all over the 9 admit cards. So we are holding those, my lord. So in that view of the matter, my lord, I think this is an absolutely disproportionate response to an incident, my lord, with which I am absolutely not considered. I have connected. And the principal is the in charge of the exam, my lord.
Yes, Mr. Datta.
Lordship, in the given order itself has been passed under Rule 6 of the Assam Discipline Habits and Appeal Law, and by the inspector of school to the competent authority.
No, that is not challenged in this petition.
That is passed in jurisdiction, not just without the authority. So, and this order has some reason also, and the grounds of passing the order has been, some ground has been given also. This ground has to be examined in a departmental proceeding. All the facts as placed by my learned senior friend, it to be examined in a departmental proceeding, which is a very primitive stage to any.
No, that's all right. What is the rule of the petitioner?
Rule of the petitioner will be examined during the course of. This is my submission.
Whether to examine that rule, his suspension is required.
There are, as my learned friend has already laid out, there is a reply, there is from the by the inspector. There is after the examination, the petitioner was placed under suspension. Lordship is aware, they are normally order of suspension is challenged.
But when it is arbitrary or illegal, this court has power to interfere with the same.
Yes, that the purpose to make ensure that order has been passed in arbitrary. For that, I will have to submit the documents and I will have to file a response for it. But I will verify the question also, or I can place a record also.
Okay, Mr. Datta, you obtain verbal instruction and you let this court know at 2 p.m. today. Borpeta, you will take verbal instruction over phone.
No, order is explicit.
No. Interim pair is there at 2 p.m.
By under reopening, I will police the record.
No, we'll say. You obtain verbal instruction at 2. If necessary, we will issue notice.
Verbal instruction in respect of?
In respect of the role played by the petitioner.
Okay.
Number 31.
Deeply obliged.
May I please, Your Lordship? My lord, this is a petition regarding promotion, my lord. The petitioner was appointed in 1994 as junior assistant in Haji Anfar Ali College, my lord. Thereafter, in 1998, his post was regularized. In the year, my lord, 28 to 2023, my lord, the outgoing senior assistant retired. Thereafter, my lord, his present petitioner's name was forwarded by the principal, the DHE, my lord, on 5/1/2024, my lord, proposing his name along with my lord SER report, DPC proceeding resolution, etc. But since then, my lord, no order has been passed till date, my lord. He is about to retire, my lord. He is 58 years old, my lord. Almost 2 years passed, my lord. And thereafter, we came to know about two orders, my lord. One passed by DHE, another passed by the government. My lord, they are requesting each other to pass an order regarding promotion of the petitioner, my lord. I have enacted both the orders, my lord.
So, who is supposed to pass the order? DIC?
DHE, it is the appointing authority, my lord. I have annexed 2 orders.
Yes, Mr. Tobelder?
Here I have to obtain inspection and this may go.
No, by the time you file your affidavit, the petitioner will retire from service.
Yes, yes.
By the time you file your affidavit, the petitioner will retire from service.
58 years.
2 years.
2 3 years if they have not received my file immediately after vacation.
My lord, proposal was sent on January 2024 by the principal, my lord, along with all documents. And there are 2 orders, my lord. Both are of 2024, my lord.
You do one thing, you obtain verbal instruction, then you apprise this court at 2 p.m. What is the status of this representation? Annexure 5.
I had already thought, so they said they will provide instruction by way of affidavit, because the person who is instruction is. I had already.
Pardon? Who
I
is?
had already spoken with the person. The person after the issue.
Okay.
My lord, a date may
Let
be.
notice go at this.
Yes, yes, my lord, a date may be fixed, my lord.
Okay.
Otherwise, my lord.
Heard, Mr.
SS Ahmed, my lord.
Learned counsel for the petitioner and Mr. Bhuya. No, Mr. Tobilder for respondent in higher education department. 1, 2, and 3. One and 2. And 3, deputy director also. And for deputy commissioner, who is appearing? Deputy commissioner? Pujai Sankodev Nagar. It's Burman for the respondent number 5. This petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to promote the petitioner to the post of senior assistant. In terms of the Rule 6 of Sub-Rule 5 of Rule 1967 and Rule 9, Sub-Rule 1 of the Rule 1973. With effect from the date of proposal, including all consequential benefits. The learned counsel for the petitioner submits that the petitioner is serving as junior assistant within bracket LDA in Haji Anfor Ali College, Doboka, Huzai. For last 27 years, and he is the senior most junior assistant of the said college. The learned counsel for the petitioner further submits that one of the senior assistant retired on 28/2/2023. And thereafter, the principal, being respondent number 4, forwarded a seniority list and other documents to respondent number 2 and proposed the name of the petitioner for being promoted to the post of senior assistant on 5/1/2024. But the same failed to evoke any response till date, and being aggrieved, the petitioner approached this court by filing the present petition. At this stage, Mr. Bhuya, Tobilder, learned standing counsel for the respondent in higher education department submits that he may be granted some time to file the affidavit in opposition, and at this stage, notice may be issued. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, and 5, since they are represented by their standing counsel. But extra requisite copy of the petition may furnish to them during the course of the day. Notice to the respondent number 4 be issued by speed post and also by usual process within a week from today. List the matter after 4 weeks. In the meantime, Mr. Bhuya, Mr. Tobilder, learned standing counsel for the respondent number so and so shall file his affidavit in opposition.
My lord,
List the matter on.
After vacation. 30 January.
Madam 32.
May please, Your Lordship, in 1997, the state of Assam Tribal Development Authority, in connivance with the Union Tribal Affairs, had established vocational centers for vocational training in 5 states, 1,000 students per year. Now, these petitioners were recruited as instructors, attendant chowkidars in these institutes. These institutes had run very well till 2017 with fund, but there was some crunch of fund. In 2019, it was closed down. But as per Article 46, which says that any promotional scheme should be continued, and in accordance with 275, the funding pattern, it had to be continued. Now, the petitioners had continued in this institution for 23 years, and many of the students, around 15 to 16,000 students by now is engaged in these activities in government and private agencies. Now, after 2019, it is closed. Now, we had made a representation to all concerned authorities, and in 2024, for the first time, Lordship would see at page 50, the director had written on 30/8/2024. Page 50, Annexure 10. The director, tribal affairs, has written to the Department of Tribal Affairs along with a status report, Lordship. Status report is at page 51. At page 52, the entire scheme is at page 51. How it ran, what was the strength of, and what is the funding pattern, everything is there. Now at page 52, at the conclusion, Lordship would see that benefit of training 8. After completion of training period, the students are engaged in different government, semi-government organization, are engaged and employed. So the VTC are required to be started for favor of STP students with immediate effect. If the state may provide the above mentioned fund under state plan, the 10 vocational training centers can be started and the training classes for greater interest of STP students. Now, the union had to take a decision on the letter and the status report. Lordship, that much Lordship may dispose out with just the directing to consider representation, the director letter and the status reports, and pass a speaking order. That much only.
Where is your representation?
Yes, my representation at page 49. 46 it starts, 47.
The chief minister.
No, Lordship. Lordship would,
I read, my lord.
Lordship, at see page 49, that I wanted to point out. Page 49, last is copy to given to all. Page 40, copy is given to all concerned, Lordship. Therefore, Lordship, if necessary, I can give a fresh representation along with the status report. They may consider, that's all. And it is the constitutional duty to provide funds. It is not that it is under 275. If there is a scheme for tribal affairs, it has to be given from the state plan.
I don't, these are basically policy decision on the government. Government takes a policy decision, my lord. Now, my lord, for a policy decision, whether a 226 court will give a mandamus to government.
No,
I am not.
Mr. Dhar, you see, his pair is to dispose of this petition in the light of the status report. So you dispose of the petition, representation.
My lord will then to give that direction to the chief minister.
No.
It is the chief minister, no.
No, not chief minister.
Chief minister, my lord. My lord will
See page 49.
Page 46, my lord. It is addressed to chief minister, my lord. Once,
No.
Mr.
Dhar,
Is copy. Copy is marked to other, my lord. So, my lord, when it is addressed to the highest, my lord, chair in the government, my lord, subordinate cannot take a decision, my lord. These are copies.
May I please, Your Lordship? Lordship, this representation has seen the light of the day. The director has taken an action on this representation.
But at page 50, now the union is sitting over it. That is my prayer. At page 50, the director has given a letter with a status report. And if necessary, we can file a fresh representation now, no harm in it. With this status report and director's letter.
Okay, then let them file a.
But man, once it is endorsed to chief minister, man.
No, they will file a fresh representation.
Deeply obliged.
Huh.
Deeply obliged.
Let them file a.
Deeply obliged.
Yes, next.
Items for admission. Item number 11.
Lord, my senior is in another court. Kindly let me be taken after some time.
Pardon?
After some time.
Record received.
Yes.
Let his counsel come. Senior counsel.
Item 12.
I think.
Roshi. In another program. Item 11. Some record was called for. Hello?
Who is Mr. Sharma? You Sharma? Mr. U Sharma, attend today.
May I please, as your lordship? My lord, in fact, an affidavit has been filed today, my lord. Perhaps it is not on record, my
It's
lord.
not on record.
My lord, only just for 2 students, my lord. They have said that I am out of the purview of provincialization. Under the 2017 Act, my lord, the minimum requirement 10 students should appear in the last year of my lord examination, but I have in my subject only 8 numbers of students, my lord. That is the stand they have taken, my lord.
So let the affidavit
My lord,
be
my-
placed on
on-
record. We will consider.
Yes, sir. I will also file a rejoinder, my lord, if so.
Okay. Heard Mr. Yerbuya, learned counsel for the petitioner. Mr. Dotto for the respondents in secondary education department. Mr. Bhuya submits that he has received the affidavit in opposition. Copy of the affidavit in opposition
File.
filed by the respondent authority.
Filed by the
today.
respondent number 2, my lord.
Respondent number 2 today.
Yes,
Then
ma'am.
the petitioner will file his reply to the aforementioned affidavit. Then he applies for listing the matter after vacation. We are allowed to list the matter after vacation, immediately after reopening of the vacation.
My lord.
And in the meantime, Restusal plus the affidavit. I
Date,
take the affidavit filed by the respondent number 2 with the record.
Timing 11.
Obliged, my lord.
May I please, your lordship? And on last occasion, my lord spent short time to produce the record, relevant record, on what ground my post has been dropped, which was not informed, and it was behind the back of my knowledge. And it is a case of my lordship of omission and error, my lord, which resulted in manifest injustice. Because if my post dropped on state scrutiny committee as well, district scrutiny committee has not been recommended, but that was not served. And it was not heard, my lord. And being unheard, and it is violation of the principle of natural justice. And now at this stage, I come to know by receiving this affidavit that my name has not been recommended by the district scrutiny committee as well as state scrutiny committee. But no opportunity was given to the petitioner regarding the drop of the post, and it was behind the back of the petitioner. My lord, and this
my lord, coordinating bench of this honorable court passed a proper order dated 8/11/2021. And being, my lord, junior, respondent number 6 and 7, their post already been provincialized. And on record, our name also appear in the Dice Code 2019. That has been overlooked, and it is a mandatory requirement. So far, my lord, this section lordship 4, subsection 2, and clause 3 is concerned,
Mr. Bhuya,
lordship.
so we have to go through the file, the resolution of the DLC and SLC produced by him today. So we'll list the matter after vacation.
Lordship.
Heard, Mr.
Date,
Bhuya,
date
learned
may be, date may be fixed, lordship.
counsel for the petition. And Mr.
Ahmed.
K.U. Ahmed for respondent number 5, 6, and 7. And Mr. P.K. Bora, learned standing counsel for the respondent number 1 and 2. Mr. Bora has produced the minutes of the meeting of the DLC and SLC before this court today, pursuant to the order dated 15/12/2025. Yes, I'll list the matter on 7. 8.
Lordship, direction will be given to provide the copy, my lord.
Whose
To
copy?
acknowledge, my lord, regarding DLC report, my lord. Because till today, my lord, we are not acknowledged. Till today, we are not acknowledged.
No, whether it is part of your affidavit.
But in affidavit, it has not been enclosed. In their affidavit, it has not been disclosed.
Okay, we'll say if necessary on next day, we'll provide it to you.
Because till today, my lord, the petitioner has not been addressed. Till today, my lord, they had not been provided. And we are totally unknown. We and the back of knowledge.
The file produced before the court today shall be kept with the record. Record on the number. Okay.
Lordship.
I
love
don't. 13 and 14. Keep the record.
Yes.
13 and 14.
Last occasion, lordship has asked for obtain instruction, lordship. Regarding lordship, may I see last order, lordship.
I have received an by exception by your updated some processes are under process my lord.
No, whether any decision has been taken by the authority.
My lord. That is instruction I have received. That's a proposal for connection of credit on daily accumulated data permitted by government. Writing of his ban on 5/6/2000 later, this is applied for application via service computer. Duly hearing which is under process of office verification.
And lordship may dispose of with directing to take decision within time-bound manner, lordship, since the progress has been made in this case, lordship. Only the decision is required, lordship, on all others, and their affidavit also admitted that we can be considered, lordship. In a time-bound manner, they may be directed.
Yes.
Well,
Within a period of 6 months, my lord.
6 months.
months.
6 months will be.
Why 6 months?
I think lordship 3 months.
My lord, we have to verify.
6 months will be long way, lordship.
Your lordship,
3 months,
Lordship, obliged lordship.
3 months.
can it be on 4 months, 4 months?
No, no,
Deeply obliged lordship.
okay.
Item 15.
13, 14, same.
Item 14.
Same,
Similar lordship in 13, 14, same lordship.
similar.
Similar.
Obliged lordship. Met this the lordship.
Hmm.
My lord, in this case, the petitioner before lordship prayed for a direction from the honorable court for his transfer to Nalbari, my lord. His wife is working as teacher at Nalbari, my lord. Initially, my lord, he was appointed as multi-purpose worker on, my lord, 16/5/2011. Then he was transferred on 7/10/2016 to Simona Bosti, Nagaon. Thereafter, my lord, considering his condition, family condition, my lord, he was attached at Kamarkushi under Nalbari, my lord, Joint Director Nalbari, my lord. Thereafter, again, he was transferred to Simona Bosti in the year 2019. Subsequently, my lord, in the year 2020, he was again brought back to Nalbari. By the impune release orders, he has been released again to work at Simona Bosti, Nagaon, which is at the distance of around, my lord, 300 kilometers from Nalbari. And
So Bora, where is your affidavit?
My lord.
Where is your affidavit?
Affidavit ideas, my lord.
they will not
But
file.
my lord, otherwise, if your lordship reads the speaking order at page 73, my lord, everything has been stated in the speaking order. That is the ground. If your lordship reads that, because he has been placed at a place in Nagaon. He is seeking transfer on the ground that his wife is working at Nalbari, my lord. So initially he approached this honorable court. This honorable court was flipped to dispose of the writ petition, directing the department to consider his representation. And then considering his representation, this speaking order has been passed at page 73, my lord. And in the speaking
But
order-
whether the office memorandum
Yes.
presently holding the field was taken into account
Yes,
by the
my lord,
respondent
everything has
authority?
been taken into consideration, my lord.
Where it is reflected?
My lord.
Where is the impugn order, page number?
Page 73, my lord.
73.
73.
Yes.
In which paragraph it was taken into account?
My lord, next page 74, my lord. It starts from second paragraph, whereas the office memorandum dated 21/5/1987 of the Personnel Department provides as point 1 that where the spouses belong to the same state service, the other controlling authority may put the spouses at the same station. Also in the first para, it is stated that as far as possible within the constraints of administrative feasibility, the wife and husband, when both are government servants, should be posted at the same station to enable them to lead a normal family life and to ensure the education and welfare of their children without experiencing any undue difficulty in discharging their responsibilities as parents on the one hand and productive workers on the other more effectively. Whereas it is noted that both spouses are serving under different state services, while the petitioner has worked in Nalbari on temporary arrangements from time to time. His substantive posting is at Simona Bosti BPH in Nagaon. His attachment at Nalbari was withdrawn by the order dated 1/2/2025 in the interest of public service, and he was directed to report back to his substantive place of posting. The office memorandum also clarifies that it may not be possible to bring every category of employees within the employment policy due to varied service situations. Whereas at present there is an administrative requirement to maintain adequate public health. This paragraph is important, my lord. Whereas at present there is administrative requirement to maintain adequate public health services at Simona Bosti BPSC Nagaon.
posting of MPW staff is based on skill requirements and availability of manpower. Accommodating the petitioner at Nalbari on a permanent basis will create a vacancy in his original place of posting and may affect public health services in that area. It is also appears government has already accommodated his personal request for many years to place him at posting of his spouse. Whereas, however, if the petitioner is able to arrange a mutual transfer with another eligible MPW from Nalbari district, the same may be considered by the department, subject to availability of vacancy and fulfillment of all procedural requirements, as it would not affect administrative functions and delivery of public healthcare. So this is the reason, my lord. So for the healthcare, because it is the primary responsibility of the government. So there, and this liberty has been given to the petitioner. If he can arrange someone for mutual transfer, then government can again consider by.
Yes, you obtain inspector.
Lordship, may kindly see page 30, my lord. What was the reason behind the, my lord, withdrawing the attachment order? This is the reason they have.
Page
given.
number 30.
Page 30, my lord, Annexure 8.
Yes.
With reference to the subject cited above, I am directed to inform you that the government of Assam has launched a dedicated portal so and so to facilitate mutual transfer for grade 3 and grade 4 employees. The portal has been live for user registration since 1st January 2025, and the SOP for mutual transfer was issued by notification that so and so. However, it has now come to notice that many grade 3 and grade 4 employees are attached to offices other than their parent offices, leading to confusing among employees in identifying their controlling offices on the portal. Hence, to address this issue, it is therefore promptly advised that the attachment services of grade 3 and grade 4 employees coming under the purview of the newly announced policy of mutual transfer be withdrawn immediately and they be reverted to their original place of posting. This will ensure clarity for both employees and profile verifying officer on the portal. This was the, my lord, reason they have cited for, my lord, withdrawing the attachment order, not the one, my lord, my friend and the speaking order is saying. But now Lordship will kindly turn to page 76.
So, Bora, this has been withdrawn.
My lord.
This mutual transfer
My
permission has
Lord,
been
there
withdrawn.
is an order subsequent to passing of the order passed by the honorable court as well as the speaking order. So that cannot be a ground.
No,
And
no,
otherwise,
this
when
order is of
many-
January 2025.
Many persons were attached to many other places. So government has decided to withdraw the attachment. And they, so that they, all the employees can go to their parent place of posting. And subsequently, there is an option. That option was given to them for applying for mutual transfer, my lord. So the reason for the posting of the petitioner at his present place of posting, my lord, this speaking order itself is staying, my lord. So there cannot be another ground, my lord.
Page 76, Lordship may kindly see, page 76.
And in the speaking, now, my lord, his place of posting was Simona Bosti Nagaon. So, my lord, in the speaking order itself, it has been stated that on his request, many times he has been accommodated in Nalbari. Many times for last several years, he has been accommodated, my lord, in Nalbari. Now, that favor cannot be a ground for his prayer, my lord, now. That he has been accommodated for so many years, now he cannot go to his original place of posting, my lord. That cannot be a ground, my lord. On his request, he was accommodated for last several years.
But in case of many others, they have done that, my lord. Page 76. Page 76. They have cancelled the attachment, my lord, withdrawal order. Page 76, 78, 77, and 78. 3 examples I have cited, my lord. 4 examples, my lord, 79 also.
Maybe we do not know on what ground they have withdrawn it.
So, my lord, why, my lord,
No,
if the cases of other persons
no.
can be considered, why
No,
not?
if on earlier occasions your case has been considered by the authority,
My lord,
then you cannot remain there for your entire service period.
And secondly,
no, my lord, what I am saying that, my lord, if
It
I
is not
cannot
your
be
matter of
accommodated,
right.
if I cannot be accommodated in Nolbari, then I can be accommodated in any nearby place, my lord, so that I can, my lord, accompany my family, my lord.
No, that's
Yes,
all right,
in terms of
but
in terms of the office memorandum, my lord, it says that, my lord, if there is no post in the particular station, they should be accommodated within nearby districts, my lord.
no, if already that has been considered by the authority,
That
then
aspect has not been considered by them, my lord. They have considered only in respect of Nolbari. They have considered
no,
only in
no.
respect of
For
Nolbari.
how many years or on how many occasions they will allow you to remain there?
No, my lord,
Remain
my
in
wife
Nalbari.
is a teacher. My wife is a teacher, my lord. Her post is not non-transferable, my lord. So, my lord, they can transfer me within the nearby districts, my lord. I'm not saying that I should be posted in Nolbari only. I'm not saying that, my lord. I should,
my lord, even.
I can be accommodated.
Also transferable,
My lord,
because
on
Peter
this-
can, his wife can also file application praying for transfer to his place of posting, my lord, in terms of their memorandum.
And my wife's
Yes.
service has been regularized recently
Any
in the
of
year
that possible.
2025.
Maybe
She has not even completed 1 year of regular service. So, my lord, she can, at this stage, her service may not be transferred. So, my prayer is
There
on
is
the
a
same
clause,
ground, my lord, on the same ground, Lordship has already allowed a petition. I have given the order, my lord, to facilitate the, my lord, spouses to stay together, my lord. So, Lordship,
Mr. Bora, can his posting be considered in the nearby districts?
any nearby
Not in
district, my lord,
Nalbari.
there is a
My
post
lord,
lying taken in, my lord,
in
Sipajar,
that
my lord.
Order itself, my lord, in the speaking order itself, it has been observed there. However, if the petitioner is able to arrange a mutual transfer with another eligible MPW from Nalbari district, the same may be considered by the department, subject to availability of vacancy and fulfillment of all procedural requirements.
No, that's all right. If there is no such candidate or no such employee, then what to do?
Then, my lord, transfer is the incidence of service.
that's all
and
right.
It is more particularly in the health sector, my lord.
No, that's all
Because
right.
speaking order clearly states that it is for the public health, considering the public. And
No,
my
no.
lord, the Honorable Supreme Court as well as this Honorable Court has been already held there. Unless, until my lord, the transfer order is vacated by malice, then if it is in exercise of mala fide power, if it has been proved.
No,
then
no,
only
that
it
is
can be
there. There is
interfered.
so
Otherwise,
Bora,
my lord, there is no scope.
there is no quarrel about the proposition.
Yes, my lord.
But
So
the
here
question
also it
is
in case of the petition that it is mala fide exercise.
No, no.
my lord. It is for the interest, public interest.
No,
and
no,
for
that's
the-
all right.
Yes, my lord.
But can he be accommodated in the nearby district? In Barpeta or in Baksa or in
My lord. Because the
Mangaldoi or in
office
Aminggaon, Kamrup?
memorandum also doesn't say so, my lord, in nearby district, my lord.
It says, my lord, it says, office
He
memorandum,
goes
Lordship,
by
kindly
the
peruse.
office memorandum, why his wife doesn't apply for posting her at Nagaon, my lord, in terms of the office memorandum. He can apply for.
No. Now
He cannot be placed at the place of posting of his wife. His wife may go there, my lord.
No, Mr. Bora, you obtain instruction as to whether he can be accommodated in the nearby district or not. Or we'll list it after vacation.
Yes, my lord.
You obtain instruction. Heard Mr. Soikia, learned counsel for the petitioner, and also heard Mr. Bora, learned standing counsel for the health department. Though there was a direction to file affidavit in opposition by the respondent authorities, Mr. Bora submits that filing of affidavit in opposition is not required in view of the office memorandum, in view of the speaking order dated. Speaking order is at page number?
Page 73, my lord.
Speaking
19/9/2025.
order dated 19/9/2025. However, Mr. Bora is directed to obtain instruction as to whether the petitioner can be accommodated in the nearby district of Nalbari. Districts of Nalbari, nearby districts of Nalbari. Place the matter on
27 January.
27.
Can it be before that, my lord, before new vacation, if possible,
No, it will not be possible by the 22nd.
22nd. Possibly keep the matter as part of my lord. Possibly start the matter, my lord.
Okay.
My lord.
This is a
No, my
legal
lord, it
matter.
is not necessary, because it is in the admission stage, my lord, part that is not necessary.
No, even in the motion stage also.
Your
whether we
lordship has
can find-
indicated what is required, what instruction is required.
Yes, already indicated.
Yes, my lord, so I obtained the instruction, my lord.
Oblige, my lord.
Obliged.
Directed me to status of a I have fixed it and sent. Maybe another place it on like a biometric.
Okay. None appears for the petitioner on call. However, Mr. Talukdar, learned standing counsel for the respondent in elementary education department present. And he submits that he has received instruction pursuant to the order dated 10/12/2025. And he also submits that he may be granted some time to bring on record the instruction by way of an affidavit in opposition. Bear allowed, let's list the matter after vacation. Later on, Mr.
R.H. Chaudhary.
Learned counsel for the petitioner entered appearance. List after vacation.
Item 33.
May please your lordship, my lord, this petition is for resume classes, my lord, because I was not allowed to attend my classes, my lord. And I am a student of my lord Downtown University, my lord. And they have filed affidavit, my lord, and we have also filed reply. And our reply, my lord, starts from page 35.
When did you file your reply?
My lord, on 11, my lord, 11/12/2025, page 35, my lord.
39.
Huh?
39.
39. My lord, they have raised question regarding maintainability, my lord. And
Okay.
regarding same, my lord, I want to place for judgment, my lord. Yes. अरे दिया है, तो दिया है।
But the question is whether a repetition is maintainable.
Yes, my lord, I have given one judgment, my lord. Kindly para 13 and
Para?
sub para 20, my lord.
Para?
13, sub para 20. Page 336. Page 336. Have you got, my lord? Sub para 20. May I read, my lord? Page 336.
Ramesh Ahluwalia again.
Yes, Mr. Decker, what is your stand?
My stand is that it is not material, that judgment has to be for inquiry in a subsequent judgment matter.
In which judgment?
2023,
No, actually, this is a quotation from another judgment.
Yes, my lord, another judgment,
Original
my lord.
judgment is V.R. Rudani.
My lord, another judgment, my lord. 2015-16.
that the matter of discipline of a student will be in the realm of discharging a public function. That is the question to be determined. There is no dispute on the preposition of law that a private body which is discharging public functions
Yes.
cannot be a state within the meaning of Article 12, but still will be amenable to the writ jurisdiction. And in this particular judgment of 2023 4 SCC, it has been clarified. When a public body, a private body, 2023 4 SCC 498. Because lordship, if your lordship holds that a writ is maintainable, tomorrow teacher of the university will also invoke the 226 powers of this honorable court, madam. Can that be done? Because
No,
it's a-
no.
It's a matter of discipline of a student, madam, disciplinary action. I'm not on the merits of the case, madam. Because the allegation is also serious that he has kicked the Indian national flag. There is a video. He was taken into custody because him being a minor, he was released. So now it's a question of discipline of the university. It's purely a private matter of the university, madam, between the student and the university.
Other, my lord, 5 persons were arrested, my lord, regarding a, my lord, by the same forwarding report, my lord, and other 2 were, my lord, 2 were, my lord, allowed to resume their classes, my
Yes,
lord.
because they
Because
were not
61 subsection 2 BNS, my lord, conspiracy is there, my lord. They were together, my lord, but so, my lord, criminal conspiracy is there, my lord. So equally liable, my lord. And now, my lord, I want to reform, my lord. I want to join my classes, my lord. My education, my lord, cannot be denied, my lord. And it is, my lord, and another aspect, my lord. This university was, my lord, established, my lord, by it, my lord, an act, my lord, passed by the, my lord. Our
That's all
legislation.
right. There is no doubt that your university is a private university.
Yes, my lord, private, my lord, but
If your lordship is taking
What?
up the 2023 judgment from paragraph 55 onwards.
my lord, because, my lord, this university is, my lord, discharging public function, my lord. So it can be maintainable, my lord. Kindly 2015-16 CC, my lord, 530, this judgment, kindly, my lord, see page 538, my lord.
Okay. Yes, Mr. Decker, you are referring to paragraph number?
55, it starts, my lord, 56, that judgment is quoted. That when there is no direct control, day-to-day of the government in the day-to-day functioning, then the institution will not be a state within the meaning of Article 12. Para 56, middle portion. So far as the statutory provisions regulating the facets of administration are concerned, lordship has got it.
Yes.
In case of an unaided minority educational institution, the regulatory measure of control should be minimal and the conditions of recognition as well as conditions of affiliation to a university or board have to be complied with. But in the matter of day-to-day management, like appointment of staff, teaching and non-teaching and administrative control over them, the management should have the freedom and there should not be any external controlling agency. Then lordship, if your lordship turns to para 59, where this judgment is the judgment relied upon by learned friend, that is considered. The principal argument before this court in Ramesh Ahluwalia case was in regard to the maintainability of the reputation against the private educational institution. It was argued on behalf of the appellant therein that although a private educational institution may not fall within the definition of state or other instrumentalities of a state under Article 12, yet a writ petition would be maintainable as the said educational institution could be said to be discharging public functions by imparting education. However, The learned counsel for the educational institution therein took a plea before this court that while considering whether a body falling within the definition of state, it is necessary to consider whether such body is financially, functionally, and administratively dominated by or under the control of the government. It was further argued that if the control is merely regulatory, either under a statute or otherwise, it would not ipso facto make the body a state within the meaning of Article 12 of the Constitution. On the conspectus of the peculiar facts of the case and the submissions advanced, this court held that the writ petition would be maintainable if a private educational institution discharges public functions, more particularly imparting education. Even by holding so, this court declined to extend any benefits to the teachers as the case involved disputed questions of fact. Now 62, my lord. Another case is discussed, then 66.
Yes.
Merely because a writ petition can be maintained against the private individuals discharging the public duties and or public functions, the same should not be entertained if the enforcement is sought to be secured under the realm of private law. It would not be safe to say that the moment the private institution is amenable to writ jurisdiction, then every dispute concerning the said private institution is amenable to writ jurisdiction. It largely depends upon the nature of the dispute and the enforcement of the right of an individual against such institution. The right, which purely originates from a private law, cannot be enforced taking aid of the writ jurisdiction, irrespective of the fact that such institution is discharging the public duties and or public functions. The scope of mandamus is basically limited to an enforcement of a public duty, and therefore it is an ardent duty of the court to find out whether the nature of the duty comes within the peripheral of the public duty. There must be a public law element in such action. My respectful submission, I'm not going into the merits. On the disciplinary, it's purely a question of disciplinary action against the student member. So whether that will come within the relevant realm of discharging public functions.
Here, my lord, respondent number 5 is performing public duty, my lord, providing education to the youth of the state, my lord, or to the nation at large, my lord. So definitely, my lord, they are discharging the public duty, my lord. So, my lord, my education has been denied, my lord.
The Mr. Sigdar, you go through the paragraph number 66 of this judgment.
My lord.
St. Mary's Education Society and another versus Rajendra Prasad Bhargava and others.
498.
You come prepared on next date? Whether the dispute between you and the management is
Yes, my lord, because my lord, my right to education is a fundamental rights, my lord. That has been denied. So,
Right to education is recognized as a fundamental right. It's not a right to education, even in spite of causing.
even my lord,
That
5
is not right
persons,
to education.
my lord, 5 person, my lord,
You behave in an unruly manner in a school. The school is prohibited from taking disciplinary action. That is not the right to education.
my lord,
With utmost respect, my lord. If he
and
is
my lord,
causing
why,
any
my lord,
discipline,
and my lord, I am a minor, my lord, and why the, my lord, Juvenile Justice Care and Protection of Children Act was enacted, my lord, to provide, my lord, protection and to my welfare of the society, children, my lord. So, my lord, I want to reform, my lord.
no.
Who
First,
others
the-
person,
Mr.
other students were
no,
not
no.
allowed.
Mr. Sigdar, you see, first you have to satisfy this court regarding maintainability of this.
Yes, my lord, it is
We are
maintained
not
because, my
bound
lord,
of the petition.
the university is, my lord, discharging public duty, my lord.
Maybe.
My
But,
providing
going to
education
this
to,
paragraph number 66 of this judgment, can it be said? Therefore, you please go through the judgment. You come prepared on next date. We will list it on 5th of January.
my lord.
Heard Mr. Sigdar, learned counsel for the petitioner, Mr. N. Dekar, learned counsel for the respondent number.
45, that's one number 5.
Respondent number 5. Ms. Corporator for respondent number 2. Mr. S. Das for respondent number 3 and 4. List the matter on 5th of January 2026 so as to enable Mr. Sigdar to go through the decision of Honorable Supreme Court in the case of St. Mary's Education Society and another versus Rajendra Prasad Bhargava and others reported in 2023 for SSC 498, especially
498.
paragraph number 66.
98, 498.
I love this problem.
Here it puts it.
Yeah.
In number 7 and 8 petitioner declared it. Instruction awaited that he fixed it, for
9-1.
instruction 9-1. Another similar matters are also listed on that instruction.
As agreed by learned advocates of both the parties, SSL lays the matter on 9th,
9
Nine.
January.
9th of January. So
Both
as to
7 and 8.
enable Ms. Borwa to obtain necessary instruction. Pursuant to the order dated, when the order was passed,
Last order.
19.
তেখেতক কৈ দিলে হ'ল, আগৰ order।
Last step to say.
Last-
Sir, আপোনাৰ
হা?
7
7 আৰু 8। ডেকা।
7.
আগৰটো তেখেতে মাৰিছে। Thank you. ধন্যবাদ, চবকে শুভেচ্ছা থাকিল। মহাবতৰ। নহয়।
My lord, kindly peruse the last order, my lord.
Yes, is there any provision in the web?
Memorandum is there, but one order I have collected, my lord. Just
Order
your
of?
lordship may peruse, my lord.
Okay.
Similarly situated.
Yes, Mr. Sharma?
Kindly peruse page number 23.
No, her contention is that the present petitioner is similarly situated with the petitioner of this writ petition number 2991 of 2022. You go through this order, then let this court know.
5497, the one of the
No,
orders
I will-
annexed
it-
with the writ petition, which is not similar lordship.
It
In
is.
this
No, no,
in
this present, this order. You go through it, you let this court know after some.
Otherwise, earlier, why it was, application was.
No, that's all right.
Timing item,
You go through the order.
timing item 29 promotion.
Yes, Mr. Dutta?
So I have spoke with the inspector of school and headmaster of the school also. There was an inquiry conducted by Assam Higher School Education Council, so Aryan Seva. On the Seva inquiry, it was revealed that the headmaster of the Chenga Girls High School and the Academy Abdul Roof and the petitioner is actively involved. All these examination work of the Chenga High School Center was done by this petitioner lordship, like filling of registration form.
That inquiry report is available with them.
With them lordship.
Produce it. Let it be on 5th of January.
But can it be 7? I don't want 4.
You are arriving on 4th. Okay. Heard Mr. Ken Soduri, learned Singh.
You will kindly record this statement, submission of my learned friend. my lord.
Learned counsel for the, assisted by Mr.
K. Kolika.
Learned counsel for the petitioner. And also heard Mr. Dutta, learned standing counsel for the respondent in Secondary Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the suspension order dated 16/12/2025 passed by the inspector of school Barpeta. Mr. Soduri, learned counsel for the petitioner, submits that the petitioner is working as LD assistant in the
Senga Higher Secondary.
Senga higher secondary or higher secondary school. And he was placed under suspension by order dated 16/12/2025 on the ground that he is involved in the anomalies in conducting SSLC examination 2025, within bracket, 5 candidates to appear in the SS examination at Senga Higher Secondary School. Mr. Soduri further submits that, in fact, the petitioner, being LDA, is no way concerned with the aforementioned anomalies, and the principal of the said school as well as the officials of SEBA are involved in the same, and the petitioner has been made scapegoat here. And as such, Mr. Soduri contended to stay the order of suspension dated so and so. While the matter was taken up during the first half, Mr. Dr. Learned Standing Counsel was directed to obtain instruction as to the rule being played by the petitioner in the aforementioned anomalies, and today, no, and at 2 p.m., Mr. Dotto apprised this court that one inquiry was conducted by, who had conducted the inquiry?
One secretary, State School Education Board.
Secretary Assam School Education Board, wherein the involvement of the petitioner along with
That other, the headmaster Division Academy, Abdul Lo.
headmaster of the Diligent Academy, Abdul Rauf, and
Not here.
He mentioned about that Sengha girl.
oh,
Headmaster.
Headmaster of Sangha Guard High School are involved in the same. And that he prays for listing the matter after vacation, so that he will place on record all those facts, including the inquiry report. Where is allowed recess and list the matter on seventh.
Interim order will consider on that day.
On that day.
Yes, Lord, you have gone through it, it is not similar. In this present, order, Lordship, the case of the petitioner was not placed before the DLC.
Lordship, I am sorry to intervene. That Seva is also here. He can also produce that, but I will also produce from our part, Lordship. He may also be directed, Lordship.
No, anyone can produce it.
Both.
Yes. You record. Mr. Sutia, you are appearing for?
I am
Seva.
4567, my
4,
lord.
5, 6, 7. Okay.
Well, at the school board, my lord.
Okay.
It is not similar, Lordship. So,
Not
Lordship,
similar.
where is the paragraph number?
Where is Ms. Chaudhary? Let her come.
Item fixed, item number 24.
May I please, your lordship?
Mr. Sharma, you see on the other day,
Yes.
by the order dated 11/12/2025, Mr. Das was directed to obtain instruction as to whether the higher education director, higher education Guwahati has been conferred the power of appointing authority in terms of the rule of 1964. That was the direction.
Yes.
And Mr. Das, on the next day, apprised this court that conferment of such power is not required in view of the new rule. Because this rule is enacted under Article 309 of the Constitution of India.
So,
And Rule 31 empowers the director to exercise all such powers. So a separate power appears to be not required here. Separate empowerment.
if the lordship may please come to 28 May 25 rule.
20?
2025 rules. 2025 rule, lordship.
Yes,
That goes at gazette notification.
yes.
Then rule 19.
Mm.
All employees of the Assam Government College shall be governed under the provisions of the Assam Service Discipline and Appeal Rule 1964
Mm.
and Assam Civil Service Conduct 1965
Mm.
and the guideline made thereunder.
Mm.
So for this is lordship on the heading,
Mm.
discipline and appeal.
Mm.
Lordship get it?
Mm.
For this purpose. So for discipline and appeal, this 2025 May rule has said that 19, that for discipline and appeal,
all employee of the Assam Government College shall be governed by the provisions of that Act, 1964.
The appointing authority role will
Now, here in this rule, Lordship,
Hmm.
appointing authority is defined at this rule, Lordship,
Hmm.
25 rule.
Hmm.
2A,
Hmm.
appointing authority means Director of Higher Education, Assam.
Hmm.
purpose to
What is the purpose?
Rule 6.
Lordship, may please come to Rule 6.
Hmm.
Lordship, I'll go slow. Lordship, because this, Lordship, I have to clarify, Lordship.
Hmm.
Rule 6, Lordship.
Hmm.
On the top, procedure of direct recruitment.
Hmm.
Then 5,
Hmm.
Roman 5. The governing body with duly signed resolution shall forward the appointment proposal of the Director of Higher Education Assam, who shall issue appointment order with the approval from the government.
Hmm.
Now, Lordship may please come to 2. 6.2.
Hmm.
The inclusion of candidate's name in the select list shall not confer the right of appointment unless
Hmm.
the appointing authority is satisfied after such inquiry due procedure as may be considered necessary
Hmm.
that a candidate is suitable for appointment.
Hmm.
So his role is defined.
Hmm.
Now, Lordship may please come to 17.
One of proviso.
Now, 17.1, then there is 2 proviso, Lordship.
Hmm.
Provided that the period of probation may be good and sufficient reason to extend by the appointing authority for any specified period not exceeding the period of 2 years. So there is appointing authorities power and is mentioned. Provided also that the member of the service placed on the probation has completed the period of probation to the satisfaction of the appointing authority and the fulfillment of the condition as may be notified. So the appointing authority is defined.
21.
Now, Lordship may please come to 21.
Second.
Hmm.
Now, 21A, there is a second provision, Lordship, in the last year, Lordship, there. 21A, Lordship,
Hmm.
at page 2478, there is one first proviso, then second proviso.
Hmm.
Provided further that if a candidate is prevented from joining within the period by circumstance of public nature or the reasons beyond the control, the appointing authority may extend it for a further period of 15 days. It's like that, Lordship, what the appointing authority will do
Hmm.
is specifically mentioned.
31 will not prevail over Rule 19.
So, this Rule 31, what my learned friend has referred to,
Hmm.
Will not prevail over Rule 19.
that the director shall exercise all power of the appointing authority as per government notification order issued from time to time.
Hmm.
Constitutional rules under Article 309.
It is a 309 thing will not cover, Lordship, because this will not go above this 19, Lordship.
This rule is enacted by the governor of Assam under Article 309.
Yes, both.
Not a delegation.
It's
So we are basically
yes, Lordship, indeed, Lordship, for that, Lordship, please.
concerned with the appointing authority.
Yes, Lordship, may please take this 64 rule law for that, Lordship.
Hmm.
6, Lordship, the Lordship, may please come.
Yes.
Word. That will have.
Lordship, after this 6, Lordship will get a notification specific from the governor.
Hmm.
Delegation has to be under Rule 6. It cannot be under.
Delegation has to be under Rule 6.
Hmm.
ID governor.
Hmm.
Lordship, get this notification, Lordship.
Hmm.
After the Rule 6, there is a notification from the governor.
Hmm.
Specific.
Hmm.
Deputy Commissioner of Power.
Lordship, get it.
Hmm.
On dated 31st May 1982, the governor has issued this notification.
Hmm.
Lordship, the Lordship has taken this new book or the old book now. Even in the new book also it is there, Lordship. Lordship can
See this, Lordship.
No, yes, it is there
Lordship.
in the old book.
Yes, old book also it is there. Now, Lordship, after this notification, Lordship, may please come to Rule 6.1. Because after the report, all these things are not necessary, Lordship, but even then, Lordship's query, I am satisfying your Lordship. Because now the report has come. And after that report, this suspension will not be there. Direct judgment of division bench is there. Suspension. Lordship will take note of the word suspension. The appointing authority or any authority to which it is subordinate or any other authority empowered by the governor, Lordship get it. In that behalf, Lordship will take note of this. Lordship will satisfy. In that behalf, may place a government servant under suspension. So the word suspension to be read with in that behalf, then governor in that behalf may place a government servant under suspension. Any other authority empowered by the governor in that behalf may place a government servant under suspension.
Delegation has to be for suspension specifically.
So delegation for suspension, it must be specific. What is there in the rule itself, Lordship, this notification. And Lordship, for that purpose, Lordship,
Very old.
Lordship, this is
1852.
1852 judgment, Lordship. Lordship, you have to read, Lordship,
Meaning of in that behalf.
Lordship, for the purpose of in that behalf, Lordship, this is the copy, Lordship, I have given just now.
Discount code. Discount for discount code.
So, Lordship, the plaintiff right to cause depends upon the construction of the 11th and 12th section of the Country Court Extension so the 11th section enact that if any action commences after the passing of the act in any of the Majesty Superior Court of Record, the covenant date, the tenure or the assumption not being an action of the breach of promise of marriage, the plaintiff shall recover a sum not exceeding 20 shilling. Or if in any court of record the trespass so the being the action of the malicious prosecution or the libel or slander or the criminal conviction, the seduction, the plaintiff shall recover a sum not exceeding 5 shilling. The plaintiff shall have a judgment to recover such sum only and not cost except in case hereinafter provided and except in the case of a judgment by default. And the plaintiff is not entitled to the cost under this section inasmuch as he has recovered a sum not exceeding 5 shilling. Then, by Lordship, now Lordship will read this. Then, by section 12, it is provided, inverted comma, Lordship, if the plaintiff shall in any such action as aforesaid recover sum less than a sum in that behalf. Herein before mentioned by verdict, the judge or the other presiding officer before whom such verdict shall be obtained shall certify that the plaintiff in such case shall have the same judgment to recover his cost.
How, Mr. Somar, how this judgment relevant to the facts and circumstances?
Lordship, I am reading, Lordship. Lordship may come to next page. I also asked the same question, Lordship. When I also the same question I have asked Lordship. One Lordship has put to me today. Lordship may please come to this is 4 judges. Lordship may come to the last Martin B. Last one, Lordship. I am the I am of the same opinion. Even upon a literal construction of the statute, the so and so, the language of the 12th section is, if the plaintiff in any subsection as aforesaid shall recover less than the sum in that behalf herein before mentioned, it is not recovered the sum here before mentioned, but the sum is that behalf herein before mentioned, which point to the sum which under the provisions of section entitled plaintiff of cost. I further think that we ought to read this Act of Parliament as with any other document with a view to understand it and give it a reasonable construction. For this purpose, Lordship, I am reading. In that behalf context, Lordship, I am reading this because in this rule, Lordship, the rule 6 is very specific, and the new rule has referred to the 1964 rule, and the 19 is not overridden by 31. And that is why whole 25 rule, Lordship will not get anything about the penalty and appeal. Lordship will not get anything. For the purpose, if Lordship will follow one act, for the purpose of suspension, this rule of 1964, then for the purpose of appointing authority, Lordship will go to the other rule. This is also, Lordship will take note.
Mr. Sharma, you see here in the rule of 2025, appointing authority has been defined.
Yes, very correct. So Lordship may please come to 64.
And you see this
And the for the
34.
purpose of 25 rule, what the appointing authority will do, that is also
This
defined.
saving clause, you see 32.
Yes.
All
60
orders.
64 is not repealed.
Oh, no, not repeal.
Yes.
The question does not arise. Repeal
Yes.
the
The
64.
64. So when Lordship the 19 said that 64 will lie, for the purpose of suspension, Lordship will look into rule 6 of the 64 rule. And for
But no, you see, the requirement of 64 rule is that the appointing authority, if he is not the appointing authority, he should be empowered by the governor,
yes,
right?
yes,
The petitioner is appointed by the commissioner,
yes,
not by the director of higher education.
yes.
But you see, this 31. The governor by this rule has empowered the director of higher education to suspend him.
No, that is
Designing
why.
him
No,
as appointing
no,
authority.
Lordship, no.
No,
For the
you see.
purpose of suspension and all, governor said you have to go by 19.
Yes.
So 19.
This 25 rule
No,
has
no,
authorized him. This 31.
yes. 31 is all right. 31, Lordship have to read it in conjunction with 19.
No, yes.
This Lordship, the 31 is subsequent to 19 only. Lordship, the 19 is very specific in the rule itself.
And you see this repeal and saving clause 32.
Lordship may please 31. Lordship
will have to be empowered by government notification to suspend.
31 for the purpose of 31, like the 64, 31 will help me, Lordship, otherwise.
No.
Lordship, yes. Lordship, why I am so? The director shall exercise all other power, Lordship,
Of the appointing authority.
of the appointing authority, all other power. That is why I have read all this appointing authority, what the appointing authority will do. The rule said. In this rule, 25 rule, it is there what the appointing authority will do. Then, as per the government notification order issued from time to time.
Notification is pre-issued.
So, Lordship, for the purpose of suspension and where is that notification?
Is
No,
not there
no.
in the rules.
Not there in the rule.
As he has been designated as appointing authority
So,
by
Lordship,
clause 31.
Lordship, then
So,
Lordship
rule
from
31.
25 rule, Lordship may show one word, one whisper about the suspension and appeal.
Maybe. That
There is
will, that
nothing.
will be governed
Then-
by this disciplinary and appeal rule.
Yes, that is what I am saying, Lordship. The 19 said that you have to go for discipline and appeal rule 1964. Then for discipline and appeal rule, you will look into the sections, rule sheet.
You say, by virtue of this clause 31, the Director Higher Education now becomes the appointing authority.
No, no, Lordship.
Not for
No.
suspension.
No, you see,
Not
you
for
see
suspension.
you
Not
see
for
the wording
suspension.
of the provision.
Not for suspension, Lordship.
No, no,
Not. We are humble, my humble,
no,
Lordship.
he
I
has the
leave.
authority, being the appointing authority.
For the purpose of appointing authority, Lordship, it is the very clear, Lordship, Lordship, please read at the cost of repetition, I'm reading. 31. The director shall exercise. Lordship,
such purpose of appointing authority.
I'll wait.
Mm.
The director shall exercise
Mm,
all other powers, all other
mm,
powers of the appointing authority
mm,
as per government notification and order issued from time to time.
mm,
For suspension, we need a notification
mm.
under 31.
No, now you come to this clause, rule 32.
Yes,
Apply.
these 32 will not come. He does
Right.
not override the 64.
No, overriding the 64 does not arise.
After the rules for repeal, savings is for the rules repeal.
Repeal and saving clause 32.
Mm,
The Assam government college service rule are hereby repealed,
mm,
provided that all orders made or action taken under the rules
mm,
so repealed or under any general under ancillary thereto shall be deemed to have been validly made or taken under the corresponding provision of this rule.
mm,
So our earlier rule
mm.
is repealed.
And savings, earlier rule under
No, all the orders.
under the repeal rule.
Under the repeal rule, Lordship.
Mm.
Yes.
Repeal rule, yes.
No.
We are not under the.
I am not under the repeal rule, Lordship, because this 19, the suspension and the appeal, the discipline and appeal is 64.
Mm. No, 64 requirement is the empowerment.
Yes.
Empowerment, this by virtue of this 31, rule 31, he has been empowered.
No. So them the
Appointing
64
authority is
notification, that is why
designated as
under the
appointing
6 one there is a notification I have shown to your Lordship by Governor,
Mm.
specific.
Mm.
It is there, Lordship.
No, it is
What
there.
is that notification?
Mm.
What is that notification,
That is
Lordship?
required under 31 also.
Even 31 that required, Lordship, now.
Mm. How?
Lordship,
another
because
purpose.
Lordship, earlier also 6 said that is why the Governor has given the notification.
The
Mm.
rules do not define anything for suspension. So it's another power.
Lordship will not get anything in this rule for suspension or the year.
So it's another power.
Where is the power of appointing authority, Lordship, in this rule?
It's other power.
Where?
This rule, new rule, 25 rule.
Mm.
It's other power.
No,
What
no.
is this power of suspension?
It should
And
be governed by the discipline and appeal rule.
yes, yes. So that is why I'm saying. So for that purpose, suspension and appeal, the 64 will prevail.
Okay, yes, Mr. Das.
That's part. No, second part, Lordship. Now all these things we may not go, Lordship.
Yes.
In view of the fact, we have not, because while I filed the writ petition,
But
the
right
report-
now, but right now, I am not accepting your this argument.
yes, yes, that is
Okay, yes.
Any lordship poses it against me. Then.
when Lordship, after that, Lordship, after this report, this suspension will not.
Okay.
Regarding residual power, my lord, 31.
Mm.
But what is residual power? Residual power is the power left over. Residual meaning is the kind of leftover,
Mm.
which has not been explicitly mentioned here in this rule.
Mm.
Those power has been given. Now, my lord, my learned senior sir has read this provision in a negative way, my lord. And I'm thanks for my lord. Kindly see rule 31, residual power, my lord.
Mm.
The director shall exercise all other powers. Now, my lord, here is the word is which has not been explicitly mentioned here.
Mm.
Those power can also be exercised. That is the meaning of residual, my lord.
Mm.
The director shall exercise all other powers of the appointing authority as per government notification and orders issued from time to time.
What is
That
that
means-
notification?
That means, my lord, some powers has been given here
Mm.
to the director as appointing authority.
Hmm.
But some of the powers which has not been explicitly given or mentioned here in this rule, those powers can also be those well, those powers can also be exercised by the director as an appointing authority. That is the residual power under 31 matter. So the argument advanced by my learned senior sir will not be applicable with respect to rule 31 matter. And regarding matter, the question which will prevail, whether 34 rules or discipline appeal rules or this matter 25 rules. Matlab, there is no conflict with respect to the definition of appointing authority mentioned in the discipline and appeal rules and 25. Why, my lord? My lord, kindly have for a moment 2B of the 64 rules. Two-
Yes.
is, my lord. Appointing authority in relation to a government servant at any particular time. This, my lord, what is important that at any particular time. This doesn't mean that at the time of appointing, at any particular time means since this cause of action is in present stage and the suspension has been done at now, my lord, we have to look into the appointing authority at this moment, my lord. So here this phrase is what is given that at any particular time. So this is variant, my lord. At any particular time, if now we have to see the appointing, who is the appointing authority now? At any particular time is the present time. my lord. Appointing authority in relation to a government servant at any particular time means now means the authority empowered to appoint him to the post which is holding at the time. Meaning, dear my lord, at present, who is the authority who is empowered to appoint him? Now, by virtue of this 25 rules, the director is the appointing authority or empowered to appoint the petitioner as the my lord, principal. So there is no conflict, my lord.
Okay, now you tell me one thing. As per the inquiry report, only 2 candidates were allowed to appear in the examination. Then that too pursuant to one recommendation, pursuant to the recommendation made by the controller of examination in their application filed before him, right? And subsequently, the controller has withdrawn those recommendations. And thereafter, the petitioner herein has not allowed them to appear in the examination, right? There is no dispute about it.
Those facts, my lord. Those persons were not allowed, my lord.
Yes, by the petitioner to appear in the examination. And the primary ground for suspension is for allowing 2 students to appear in the examination despite absence of the 70% of attendance. That is the ground.
Let me have it.
You see the suspension order.
Allow students to appear in the LLB examination despite their attendance being less than 70%, and in some cases, the attendance 50% of the building code.
There is no other charge against him.
2 students in suspension order, indicates the paragraph, 2 students.
There is no other charge except this.
I could not find the.
Pardon?
It says that in second paragraph, in suspension order, page 72, it says that whereas on principle, the inquiry team submitted its report after careful examination of the inquiry report and all relevant documents, it has been found that the principal of so-and-so college allowed students to appear in the LLB semester's examination despite their attendance being
Yes.
less than 70%.
Mr. Das, you see, this suspension order is based on the inquiry report
Yes, yes.
constituted by the Director of Higher Education at the instance of the Education Minister.
Yes.
And it is reflected in the suspension order also.
Yes, madam.
And here, in the inquiry report, it is stated that they have the 3 members inquiry committee has recommended for suspension of the petitioner, right?
Yes, ma'am.
You see the recommendation? Last line.
Just a Which para, madam?
Right?
Which para, madam?
Last line.
Last time. In view of the above findings, fair, transparent, and detailed departmental inquiry be initiated against the principal regarding all allegations leveled against him. Action may be taken under to ensure that no evidence is tampered with and the inquiry remains impartial. It is recommended that the principal be temporarily withheld suspension.
And further, from the suspension order, it appears that the minister has directed
Yes, madam.
the Director, Higher Education, to constitute a committee
Yes,
and to inquire the matter.
yes, madam.
And there is a recommendation in the inquiry report to suspend the petitioner.
Yes, madam.
And going by this order, can it be said that the director has independently applied his mind while placing the petitioner under suspension?
No, this inquiry is a preliminary inquiry, madam. Because
Yes.
the allegations is that Manoj he has tampered with the Manoj attendance sheet and Manoj allowed certain students to who do not have 70% attendance as written
No,
under
where is the finding to that effect by the inquiry committee report?
Manoj, the tampering word is not there, Manoj.
Then?
Although I'm saying
Then?
tampering, Manoj, but the intention is that Manoj.
So
that
we have to go by the words mentioned in the inquiry report and the suspension order.
Here since that
If nothing is there, we cannot assume that it is there.
here Manoj says that while kindly have the first page of the inquiry report, man.
No, you come to the finding,
Finding, Manoj, that
only 2 students. Right? And there is no other allegation against the petitioner.
So finding number 1, but 2 students attendance below 50% were allowed to appear in the examination, which is direct violation of so.
But that was withdrawn by the controller of examination, and those 2 students were not allowed to appear in the examination. That is the statement made by the
That is the
learned counsel for the petitioner.
that is the statement made by the petitioner, Manoj. Manoj, whether these students are that students recommended by the controller or not, Manoj, I have to verify. Because Manoj,
No, on the other day, you have been given the opportunity. You failed to
no, Manoj, record. I
obtain the
submitted them,
names of those 2 students.
Manoj, in my humble submission on the first, on that day also I said that the record has been in the custody of the petitioner and my lord has asked.
No, this Mr. Dot,
My
Mr. Das, you see,
on what Malad ground or what region Malad the petitioner is holding the custody of that attendance sheet, whether
no, Mr.
it
Das,
is
you say,
private property, my lord.
no, may not be. You see, in this
Yes,
second
madam,
paragraph of the inquiry report, In compliance with the said direction, we visited BRM Government Law College on 8/12/2025 and conducted an inquiry into the matter. During the visit, the principal, faculty members, and the concerned students were interacted with, and the relevant documents were examined. Hmm? Is there any allegation that the petitioner has not allowed you to inspect the documents, the registers?
No, that day was examined, but
Then
that day was examined, but.
why they fail to
Only
name the
mistake
students?
committed by the, only mistake committed by the officer was that they did not seal the documents, my lord. That
Okay,
is the only, way. And my lord, if my lord allow, my lord, after, my lord,
Okay.
concluded, my lord, I have.
we'll allow you to file affidavit in opposition. You file it. Today we are issuing notice and staying the order on two grounds. One is
My
the
lord, allow, my lord,
gra-
I can produce, I think photocopy, my lord, which I have been able to get hold of, my lord, regarding the attendance sheet, my lord. Although it is in the custody of the petitioner, my lord,
Hmm.
some of the students have actually, photocopy those.
Okay, all right. On
If-
two
if my lord
counts,
allow, I can place, right now, my lord.
on two counts, this impugned suspension order is state. One is the director has failed to apply his mind independently. And secondly, the ground of allowing two students to appear in the examination spans force S. Those two students were not allowed to appear in the examination after the withdrawal of recommendation by the controller of examination. So,
That was the submission made by the petitioner only, that those two students are the students which were allowed by the controller only. I am
No.
not admitted to that fact, my lord.
I am not asking you to admit it.
Yes, my lord.
We are staying the order.
Lordship, I'm grateful.
Recessal is the matter after vacation.
My lord, kindly,
So no, in the meantime, Mr. Das shall file his affidavit in opposition.
my lord, kindly consider one thing, my lord. If he joined the force, my lord, and if there is a, my lord, since there is an allegation of, my lord, with regard to the attendance system, my lord,
Hmm.
and if he joined, it is in his custody only. So my.
No, that
only
cannot
concern
be,
is, my lord, to, pass an order to authority to seek that, those, attendance, my lord.
No, no,
Before-
since we are
Those, my lord,
staying the
accident
order,
was, my lord. So the entire fact and allegations, the factual part is in his court, man.
as because he is the principal of the college.
Yes, but that are not his private property, my lord, in my humble.
May not
submission.
be.
If he has, my lord, in my humble submission, the department has a right to, my lord, on those allegations.
Hmm.
If my lord, although my lord is, saying that suspension order, my lord,
Hmm.
the department has a right to put an detailed inquiry, my lord, or give a so.
You inquire it.
This, my lord.
You
For
inquire
those-
it.
For that purpose, my lord,
Hmm.
but before that, if the petitioner, my lord, manipulate those attendance sheet,
Hmm.
that nothing will be left, my lord.
Okay, you
That
file
is the
one,
only concern.
you file one IA, on next date we will see it. Yes. next
I'm
item.
grateful, man.
I don't fix that, yeah, 24 and 25.
May please, your lordship. My lord, I am appearing for item number 35, my lord. My lord, look, we have filed one, my lord, miscellaneous application, my lord.
You're for this managing committee.
Yes, my lord.
So there was a direction to produce the NOC.
Yes. My lord, lordship kindly going to that order, my lord, for a moment, my lord, that last,
No,
yesterday's order, my lord.
First you produce the NOC, only then we will hear you.
My lord, I'm sorry, my lord, yesterday I was not present due to my personal
No,
difficulties. my lord.
I'm not concerned with your presence.
So, my lord,
He was specifically
yes,
directed
my
to
lord,
produce
lordship,
it.
lordship kindly, for a moment, my lord, for
No,
a
no,
moment,
no.
my lord.
Unless you produce it, I will not hear you.
My lord, lordship has observed in this order on 13/10/2024, 5, my lord,
Mm.
that, lordship kindly
My lord, that is, my lord, last but one paragraph, my lord.
Hmm.
Having heard. the
You first comply with the order, only thereafter we will hear you.
No, my lord,
Otherwise,
my lord, then, my lord, in the IA, my lord, notice has already been issued, my lord. Your
no,
lordship.
maybe.
Yes, my
You first produce the order, thereafter we will see.
lord, lordship was observed
You
that,
are-
my lord, no order has been passed, my lord.
Pardon?
My lord, lordship has observed yesterday, my lord, that no order has been passed in IA, my lord. But, my lord, in the actual facts is that notice has already been issued, my lord.
Maybe.
My lord,
Despite there is a direction to produce the NOC before this court, you produce it.
my lord, lordship kindly produce that order, my lord, for a moment, my lord. That.
No. We will not hear you unless you produce
My lord,
the
lordship.
comply with the order.
My lord, lordship.
Sorry.
My lord, my
Sorry.
purpose.
Next item.
Orders, item 19.
You produce the order before this court, only thereafter I will hear you.
My lord, then, my lord, in next date.
No next step. Specifically, he was directed yesterday to produce at 2 PM today.
Yes, my lord.
Where is the order?
My lord, in the IA, my lord, 3494, my lord.
Hmm.
When, my lord, I filed my
No,
leave
no.
petition, my lord.
No.
And, my lord, alleging that, my lord, some irregularities is there, my lord. So, my lord.
Maybe therefore we have directed to held up 25% of the
Yes, my lord.
pensionary benefit.
But, my lord, in the read proceeding, my lord, School Management Development Committee was not a party, my lord.
Pardon?
My lord, in the read proceeding, my lord, I was not a party, my lord.
Maybe.
And, my lord,
Maybe.
that's why, my lord, we have filed, my lord, IA, my lord, for
Maybe.
my lord, grant of, my lord, leave for to
So
file
you
review
just produce
application.
the order only, NOC only, then we will hear it. You comply with the order of this court.
My lord,
Or
kindly-
face the consequence.
my lord, then, my lord, kindly, my lord, my lord, immediately after, my lord, application, my lord.
Who is for the petitioner? Mr. Sarma, learned counsel for the applicant in I number 3495 of 2024. Price for producing the NOC before this court on next date. Pair allowed, recessal is the matter on 5th of January 2025.
Item 19.
On 18th, was a letter has been communicated in this matter to the inspector regarding the documents which are required from the council. Stating that.
Mr. Sarma,
Otherwise, all the public were competent. Now, perhaps that second paragraph of the letter.
Second paragraph. However, the remittance of pro rata pension and other service benefits, cash equivalent of leave salary and admissible gratuity, along with calculations, it is required to be transferred to Assam University check for counting combined service benefits.
Basically, the amount in this rate has to be limited. So perhaps I will communicate to this part of regarding this to the inspector of the school. Otherwise, all the pencil documents, the person will see entire document was limited. Only now submit.
no, you have to transfer this amount to the Assam University.
I will communicate. I am referring on.
Heard Mr. P.K. Das, learned counsel for the petition.
I am referring on behalf of Mr. SLT.
Mr. Zaid, learned counsel appearing on behalf of Mr. Kyle, learned. Sending counsel for the respondent, contender number 1. Pursuant to order dated 15/12/2025, Mr. Jain has produced the letter written by the register Assam University to the inspector of school CDC Kasar, CDC Silsor, dated 18/12/2025. Perusal of the said letter indicates that the remittance of pro rata pension and other service benefit within bracket cash equivalent of leave salary and admissible gratuity along with the calculation sheet is required to be transferred to Assam University Silchar for counting combined service benefit. But the same has not been received, and as such, the pension and pensionary benefit of the petitioner could not be released and could not be released. At this stage, Mr. E.N. Sharma, Learned Counsel, appearing on behalf of Mr. S.M. Trisesti, Learned Counsel for the respondent, contender number 226, submits that a copy of the letter may be furnished to him so that necessary instruction may be obtained from the Inspector of School CDC Kasar on next date. We are allowed a copy of the letter dated 18/12/2025 be furnished to Mr. Sharma during the course of the day so as to enable him to obtain instruction about the status of the letter dated 18/12/2025 and apprise this court on next date. Place the matter.
Also, that letter has already been furnished.
Place the matter on. The letter produced before the court today shall be marked as an excerpt. Annexure Z and be take to the record. List the matter on. Hastik, there's a pension matter, 9th of January. Oblate.
Item 20.
May it please your lordships. My lords, on the last occasion, your lordship was pleased to issue two directions, my lords. First direction was issued to the contenders to bring instruction as to why the petitioner hasn't been allowed to join his services, my lords. And secondly, we were directed to bring on record the service of status upon the contender number 1, my lords. And I have filed one affidavit yesterday, my lords. It shows that, my lord, service is complete. The contender number 1 has received it on 30th of October 2025, my lords.
No, we are taking up this item number 20 now.
Yes, my lords, 20. My lords, may kindly peruse the last order, my lords.
Mr. Das?
The appeal was under some objection, although now the objection has been removed and it is likely to be displayed in the January 1st week. I think, second week. So, I humbly pray that this matter may be taken up after review vacation. In the meantime, if you get the stay on the, then it's okay. Then otherwise, no. I have given the and moreover, another thing, in the order, my lord, can let's see the
No, Mr. Das, you say,
page that
this order was passed on 16/5/2025.
Yes,
Okay.
kindly see page 38, para 47 of the order.
Okay, let it be after vacation then. Heard, Mr. Das? Learned Counsel for the petitioner, Mr. S. Das, Learned Counsel for the contender number. You are for contender number 1.
Yes, madam.
1, 2 and 3.
2 and 3, my lord.
2 and
For
3.
one, my lord, I have to file the power, my lord. I will file in the next day, my lord, before the next day.
Mr. Das submits that he has filed his power.
I
You will file or you have already filed?
file with respect to 2
he will file his power
After five, my lord.
to appear on behalf of the contender number 1 also on next date. Further, Mr. Das advises court that an appeal is being preferred against the judgment and order dated
16/5/2025.
16/5/2025. And the same will be listed after the vacation. And as such, he applies for listing this matter after the vacation. Pair allowed, recess shall list the matter.
You vacation, my lord.
In the COVID,
22nd.
22nd of January 2025.
Oblige, my lord.
21.
May I please, my lord? My lord, I have filed for implement. Please come to my lord, page 3. The OP3 will be the respondent 3, my lord.
Heard, Mr.
L. Deca.
Learned counsel for the petitioner and Mr.
Partially on behalf of the, look, for respondent pro one.
Learned counsel appearing on behalf of Mr. P. Nayak.
Dina,
D. Nat for the respondent number,
respondent pro one, lordship,
respondent number 1.
lordship.
Mr. Sharma for the respondent number 2. This interlocutory application under section 11 and 12 of the Contempt of Court Act. This interlocutory application is preferred by the applicant for implement of the implement of Sri Abhishek Jain,
Yes.
the District Commissioner Hailakandi as respondent number 3. Respondent number 3. In the contempt application, in the contempt case
544.
being contempt case number 544 of 2024. The learned counsel for the applicant submits that the District Commissioner Hailakandi, Sri Abhishek Jain, District Commissioner Hailakandi is a necessary party in this proceeding, in the contempt proceeding, being so and so, so and so. And as such, he has to be implemented as respondent number 3 in the said contempt proceeding. The learned counsel appearing for the opposite parties submits that they have no objection. Any objection? No, no objection. In the event of allowing this application, accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Being the necessary party, Sri Abhishek Jain, the District Commissioner Hailakandi, be implemented as respondent number 3 in the in the contempt proceeding number so and so, so and so. In view of the order passing this IA, the applicant shall file amended cause title in the contempt proceeding number so and so within a period of 1 week from today. Rest shall list the contempt proceeding after vacation.
Timing item 4.
Oblige, my lord.
It is not a similar case, no, see?
The order which supplied
The friends. The matter was not at any point of time placed before the DLC. Paragraph number 2. Last second line. Paragraph number 2. He submitted her application on 1/2/2017. The grievance raised is that the said application had never not been placed before the DLC concerned as yet. So the case was not placed before the DLC. But the same is not the case here in respect to the petitioner. The lordship may kindly come to page number 23. Our case was the wife of the deceased employee applied for.
No, that was placed before the DLC and it was rejected.
It was rejected on merit, Lordship.
Mm.
Case number 23, serial number 28.
It was rejected
So,
on the ground of
madam, you say
qualification.
direction was to apprise this court as to whether there is any office memorandum or any act or any rules regarding consideration of the application filed by the son who attained majority after rejection of the claim of the mother.
I did
earlier.
not find, my lord. I did not find any such OM or. That is why only this is some, this has got some similarities to only this order, nothing.
No, he submits that the present petitioner and the petitioner in WPC number 2991 of 2022 are not similarly situated.
Only that
Okay,
after
the-
attaining majority, he applied, that is there, and so only for placing his case before the DLC.
You
that-
see, if there is any such OM or act or rules,
That DLC. may
we
consider-
are not taking any decision, we'll list it after vacation. If there is any, you produce it. Otherwise, we take a final call after the vacation.
Yes, my lord.
Art is SB Soduri, learned counsel for the petitioner, Mr. P. N. Sharma, learned standing counsel for the respondent for the elementary education department. And Ms. Bowman for respondent number.
46.
List the matter. After vacation, after Bihu vacation. And in the meantime, Ms. Soduri shall comply with the direction issued by order dated 10/12/2025.
Yes, my lord, I'll get sufficient time to, my lord, collect.
After vacation.
Yes, my lord.
After Bihu vacation.
22.
May I please, Lord? Lord, kindly please the last order, my lord.
Mm. So the Treasury Officer Dhuguri has not received the advice slip.
Advice, Lordship, that is on the basis of which the payment is paid. And then, as per the last communication, non-roll certificate was also required. That has been forwarded yesterday, Lordship. Because since there is no advice slip, Lordship, payment cannot be made. So the non-roll certificate we have issued yesterday only.
To the-
Only, Lordship,
To whom it has, you have issued the non-renewal certificate?
to the authority who has written to us, Lordship.
Secretary,
Lordship.
School Education.
Yes, Lordship. So upon receipt of the advice slip, Lordship, we can make the payment. That is the bill, Lordship, basically.
Okay, heard Mr. A. Hussain, learned counsel for the petitioner. Mr. Dotto for the respondent, number 1, 2, and 3. Mr. Anybody for the respondent number 5? No. You are. Your name, please? K.K. Mehdi, learned counsel appearing on behalf of Mr. S.K. Mehdi, learned counsel for the respondent number 5, and Mr. Soliha, learned counsel for the respondent number 6. Pursuant to the order dated 15/12/2025, Mr. Soliha has obtained instruction from the Treasury Officer Dhuri. And on the basis of the said instruction dated 18/12/2025, Mr. Soliha submits that the advice slip has not been received by the Treasury Officer Dhuri, and as such payment would not be made could not be made. And non-dual certificate is issued by whom? The Treasury officer?
Treasury officer.
Gwalpara.
No, no, Dhubari Lordship. It was issued by this concerned treasury officer.
No, no. The person hails from Dhuburi,
Yes, Lordship.
petitioner.
Yes. So initially they had sent it to Gwalpara, Lordship. The first time when it came.
No, no.
Yes.
Yes, they have wrongly issued to the Treasury officer Gwalpara.
And
No,
subsequently.
non-dual certificate is to be issued by whom? Treasury officer Gwalpara or Dhuri?
The Lordship.
How?
Because, no, Lordship, because the Lordship, whether or not the petitioner will get the amount, it has to go through the accounts and the account is.
No, no. If the advice slip has not reached the office of the Treasury,
Yes, Lordship.
Dhuburi, then the question of issuing non-dual certificate by him does not arise.
It was not required, Lordship, but still, since it is, they have written to the
No,
authority. as-
Mr. Soleha, whether you have obtained instruction from the Treasury officer Gwalpara or not.
Not from Gwalpara, Lordship, Dhubari, Lordship, because that was admittedly, that they had mistakenly sent it to Gwalpara. Gwalpara has no record only because that school does not exist. It is in Dhubari, Lordship.
No, no, the question is whether Gwalpara Treasury has returned the advice slip to the issuing authority or not.
Lordship, they have sent it to, Lordship, they are writing to the authority in Dhubari. So from Gwalpara, I have only sent the communication and Gwalpara has no record only, Lordship, regarding this matter. Because
No,
this,
maybe, but they have admittedly issued the authority to the advice slip to the Treasury officer Gwalpara mistakenly. So the
then that.
so the non-dual certificate has to be issued by the Treasury officer Gwalpara.
Lordship, no, Lordship, that was mistakenly written over there, Lordship.
Yes.
That because the Lordship, the payment has to be made by Dhubari.
Hmm.
If the payment has not been made, so it is the authority, treasury officer Dhubari who will state
No,
whether.
no,
or not-
you could not get my point.
Lordship.
My point is, Dhuburi Treasury officer is not authorized to release the payment.
Dhubari will release the payment, Lordship.
But no, advice slip was not issued to him. It was issued to the Treasury officer Gwalpara.
That Lordship, I have. So if Lordship, but then they have written to the Gwalpara treasury officer from the secretary asking for it. They have, then Lordship, why is the department asking the advice slip from Dhubari, Lordship, if they have issued it to Gwalpara? The communication of the education department, they are asking from Dhubari treasury officer. If they have issued it to Gwalpara, they should have asked from Gwalpara. That communication is not there.
Where is that communication?
Communication. Lordship will see the last instruction which was placed by the education department there, asked from the non-dual certificate as well as the advice, original advice slip from the authority in Dhubari.
No, Gwalpara.
No, Lordship, subsequently they corrected it and then they have issued another one, on the basis of which I had,
No, it was written to the Treasury officer Gwalpara.
Lordship, on the last date.
29/11/2025.
Yes, Lordship, pursuant to that, the matter came up again, where my learned friend placed an instruction where they had made the correction and written the, I have the copy of the letter, Lordship, with me in my phone, Lordship, if I can.
No, now Mr. Soleha, you obtain instruction from the Treasury officer Gwalpara whether he has returned the advice slip with non-dual certificate to the department or not.
Lordship, here my learned friend has that communication where they have written to the Dhubari treasury officer asking for the advance slip and the non-dual certificate from the Dhubari officer also.
Where is that letter?
Lordship, it's the last one. The Lordship might be on the court record also. My friend has the communication on his phone.
No, on last occasion, I have placed an instruction there from 9th of December.
Hmm.
We have listed to Church Guri, which appends to the letter above. I am directed to request you kindly to return the original advice slip and non-royal certificate of current financial year. Collected resection of amount of the so but.
When you have produced it?
The last date, Lordship. Last date. This was such a capital fine.
No, one letter was produced on 9/12/2025, where it is stated that it was written to the Treasury Officer, Gwalpara.
Yeah.
Oh,
Lordship, after that, they had corrected it and sent another one to Dhubri. They had admitted it's not Gwalpara, it should be Dhubri. There also they have asked for an advice slip and a non-roll certificate from Dhubri Treasury Officer also.
The basis of that lawsuit directed the finance department to obtain instruction whether the advice given or certificate has been returned to the department or not. But as per today's lawsuit, they have submitted that they have not received the advice. They have, despite that, they have issued a non-roll.
Since Lordship, we have not received the advice slip, we cannot make the payment. So non-roll certificate is basically confirmation that we have not made that payment to the petitioner. That we have issued. Now they have written it to Gwalpara and Dhubri also asking for advice slip.
Last order, the flag number of the same. Last order. Last order, the flag number. This the flag problem. You can font of it. So. Video order sheet. We do.
that letter is not available on the record.
Lordship, I can mail it.
One letter is available. As for that letter, the Treasury Officer Gwalpara was asked to return the advice slip.
Yes, Lordship, I have my learned friend also, I can send it to the mail, Lordship. It's there.
No, now the issue is, you asked the Treasury Officer Gwalpara whether he had returned it to the department or not,
Lordship.
along with non-royal certificate.
Did he ever receive it also, Lordship? I'll get an instruction because Lordship, they have written the same communication to Gwalpara as well as Dhubri, Lordship.
Mr. Dutta, so if this kind of things are going on,
Yes, Lordship. We also understand that due to some mess between the two departments. So that Lordship matter be fixed after vacation, we will sit together both council and communicate with our concern officials also. To wrap up the issue, Lordship.
Where it's written that from Dhubri also they have asked, Lordship, I have to come, I can give a printout of.
no, the issue is that Dhuburi Treasury Officer is not at all authorized.
Yes.
Advice slip was not issued to him.
Yes, Lordship.
It was issued to the Treasury Officer Gwalpara.
No, Lordship, that is also on the basis of communication. The same communications they have written to Dhubri also. So the Gwalpara has nothing to do with the petitioner, Lordship. So
Yes.
on the last date, it was admitted that they had wrongly sent it to Gwalpara and it was corrected and then it was sent to Dhubri. And that body of the letter has been same in both the matters. That they have asked for advice slip as well as the non-roll certificate from both the treasury officers. So I can get the instruction, Lordship, but I seriously doubt if they can produce anything to show that any advice slip has been issued to any of the treasury officer. I can get my instruction then, Lordship, if my learned friend can show anything. There's some confusion, Lordship, because now if it has
No,
never been-
it appears that the confusions are intentional.
Lordship, not.
The person concerned has been doing all these things intentionally. If the petitioner served in Dhuburi district and retired from there, where is the question of sending it to Gwalpara?
Lordship, that's Lordship, I'm trying to submit that on my Lordship.
If you fail to settle the issue by next date, this person concerned responsible for this shall have to suffer consequence. You let him know that we are going to harsh step on next date. Heard Mr. A. Hussain, Learned Counsel for the petitioner. Mr. P.P. Dutta, Learned Counsel for the respondent number 123. Mr. Kolu nagi etu agot. Rest shall list the matter after vacation on 6. In the meantime, Mr. Soliha and Mr. Dutta, Learned Standing Counsel for the Finance Department and the Department of School Education, said sit together and resolve the issue and apprise the outcome of the same before this court on that day. And in the event of failing to resolve the same, the court will take a serious view upon the matter, upon the person responsible for all this mess. But this accordingly.
Obliged, madam.
May it please your lordship. Here I have made a prayer, a limited prayer, my lord. So for the address of the respondent number 5 is concerned, I may be allowed to, my lord, thus make correction in the cost title. So for the address, new address, and I may also be permitted to cause service of notice upon the respondent number 5 in the new address, which is I have mentioned at paragraph number 7 of my IA. Page 5. Present one is his my lord, residential address, and the earlier one my lord, official address.
Any objection, madam? No. But Mr. Sharma, Learned Counsel for the applicant, Ms. Arborva, Learned Counsel for the opposite party. This interlocutory application is preferred by the applicant. To take step for service of notice upon the opposite party number 5 at his address, at his new address, at his residential address, or alternatively, to allow the petitioner to substitute the address of the respondent number 5 in the writ petition. The Learned Counsel for the opposite party number 1 submits that she has no objection. Accordingly, taking note of the submission of Learned Counsel for both the parties, this interlocutory application stands allowed. The applicant is allowed to take step upon the respondent number 5 in his residential address.
My lord. Meanwhile, I may be allowed to make correction in the cost title.
Okay,
So
in
far,
view of the order passed in this IA, Mr. Sharma shall, the petitioner shall file amended cost title in the WPC number 6272 of 2024 within a period of 1 week
Fine.
from today.
my lord.
Any other?